Please to direct the registry to post the matter for orders, my lord. Meanwhile, my lords, the writ court, my lords, of the Honorable Gulbarga bench has passed the order directing not to transfer the matters. But no reference is made, my lords, to the division bench matters. But we assume, my lords, that what would apply to other matters would apply here also. But in view, my lords, of the embargo, the situation is, my lord, that the matter will neither be transferred nor will be heard. My lords, in that view of the matter, my lord, at least in extreme urgent matters, if your lordships are directed to please, my lords, the registry to post the matters tomorrow, my lords.
Yes.
Deeply obliged.
At this very urgency.
Yes.
Today's suit schedule property was already bid amount that was deposited in the trial court that was confirmed. We have executed a sale deed through court. So matter is very urgency for today at 2:30 list, my lord.
Can it not wait till tomorrow?
Please, my lord.
Tomorrow,
Please.
please make available a copy of the order also.
Let's, the LRs of the appellant have filed an application to come on record, and there is an application for condonation of delay. Might kindly be taken up tomorrow.
Which is why I'd like to see the order, so let us see. And so that is the amendment of the High Court Act is not stayed. Yes, we will speak to the First Artificial Chief Justice. Please make available a copy of the order as well. And then we'll have to decide whether it has to come here and post it tomorrow, no difficulty. Here or the single judge. Because it appears the High Court Act is not under challenge, nor has it been stayed. Not stayed.
Okay, my lords, kindly, one matter my lords have heard and reserved the matter.
The,
Day before yesterday, my lord,
yes,
my lords have. heard-
punishment,
Please,
the penalty matter.
penalty matter, but I'm sorry, my lord, I'm troubling my lords.
Of course.
Two judgments, my lord, that useless formality theory cannot be applied
Correct.
for departmental inquiry.
Correct. We were with you on that.
You have to mention also.
Yes, please make it.
Sorry, my lord.
We were with you on that point.
Mate,
Any mentioning?
please, your lordships.
Please make it available to the other side as well.
Yes, I have. Before
Ma-
giving. report, my lord.
Yes.
You have any judgments to cite?
Mate, please, your lordships. My lords. One memo,
Yes.
my lords, I am out station. One memo I had filed on 11th of June, and the date by the court officer was given today, but it has not been listed. That was for
An
list.
RFA?
My lord, one is RFA of 2021 and one commercial appeal, and both have been clubbed, my lords, by order of Honorable CJ. Order of Honorable CJ, my lords.
Yes.
So I want,
You wanted.
I want, my lord, the IA for early hearing, it may be listed.
Oh, commercial appeal, we don't have those. Where does it go? Second. Second person.
But here both are clubbed, my lords, by order of Honorable CJ. Both have been clubbed. That is the issue, my lords.
It may have been clubbed, but the
Ma'am.
difficulty is it will have to come along with the commercial appeal. The commercial appeal is where we have jurisdiction. Therefore, it will have to come with the commercial appeal. Commercial appeal, the roster is not with us.
Yes.
21 commercial appeal.
So, my lord,
Roster is not with us. It is with another bench.
so what about, let's I'm putting question to myself, RFA of 21. Because both are clubbed. That is the problem, my lord.
Ideally, now the matter has to be listed along with the commercial appeal.
Okay.
The commercial appeal roster is not with us.
My lord,
Probably it is quotal number 2.
obliged,
Very
obliged, obliged.
Any mentioning? List 1, page 3, see number 15 to 19.
Same, my lord, my serial number 16. I appear for the appellant at the above matter. I request for a date in the next week, my lord.
Yes. Notice has to go.
We, by inadvertence, we failed to file an IA for stay in the above matter, my lord. We'll receive the stay applications.
Yes.
Okay.
Next Monday.
Okay. 1-7. Page 4, 20 to 26.
Your Lordship, serial number 19931.
Huh?
25.
Serial number
25.
25.
Asking for adjournment, Your Lordship.
Here for petition.
I am for
Serial
the
number
25.
25,
I am for the respondent, my lord.
19931.
Yes.
Please. But it was heard for some time anyway. One judge adjournment may be given. This senior informed me.
Yes.
Please.
Okay.
2-7. Page 5. Serial number 27 to 33.
My lord, serial number 29, my lord. I need a week time, my lord. Want to get some instruction and documents, my lord. For that reason,
You're for the,
I am for the petitioner, my lord. Interim order is there, my lord. Kindly extend it.
2-7.
Please.
Page 6, serial number 34. List 1 order, serial number 1. Peter Narayan Hegde.
Yes, my lord, I appear for the petition. It is the case of departmental inquiry. And insofar
what is
as
the office objection?
Pardon?
What is the office
Office
objection?
objection
raised?
is concerned, my lord, I have produced the translated copy of the relevant
Third.
document now. Other office objection I have attended. It may kindly be taken up for admission. Now, along with a memo, I have produced the relevant, please.
It is submitted that the office objections stand complied with.
Today it may be taken up, my lord, for admission. It may be
30?
possible.
230 or pass over?
230, password.
Pass
Could be,
over.
please, please.
Serial number 2, DP Mahesh.
For the appellate. Since the order is passed under order 38 rule 5, no appeal filed provided under order 43 rule 1. Therefore, it has to be writ petition GLCPC. There is one order. May be converted.
This appeal is filed challenging the order passed by the commercial court in exercise of power under order 38, rule 5 of Code of Civil Procedure.
2, 3, 6 is provided, not 5.
Rule 3 is provided, appeal is,
2, 3 and 6.
yes,
Other
5 is
than-
not provided.
Not 5.
The appeal is filed invoking section 13A of the Commercial Court Act. The Commercial Court Act, section 13A of the Commercial Court Act doesn't provide for an appeal against an order which is not enumerated in order 43, rule 1 of the Code of Civil Procedure. Hence, the present appeal is not maintainable. Appeal is dismissed as withdrawn. The petitioner is given liberty to file. Seek conversion.
Yes, convert.
Petitioner is permitted to file the appeal into writ petition. The appeal is disposed of for statistical purposes.
Okay.
Serial number 3, Gopala.
Appeal for the appellate. That I have filed the appeal against the input judgment and the judgment and decree passed against the third respondent, my lord. I am not a party to the suit, my lord. The office has raised objection whether the mentality of the appeal and also the court fee with regard to the court fee, my lord.
No, you have to file an application seeking permission.
Yes, I have filed an application, my lord, under section 1. Filed an application, my lord, of seeking permission to prefer an appeal, my lord.
What are the office objections? Who is respondent number 2?
My lord, respondent number 2 is a son of the first respondent, my lord, but I will going to delete the respondent number 2, my lord.
Want to delete him?
Yes, my lord.
You either must delete him or there must be an application for impleadment.
Seeking permission to delete the respondent number 2, my lord.
Learned
My
question
lord,
for the
the
appellant submits.
eviction
that,
decree,
It does not press the appeal against the second respondent. Submission is placed on record. Appeal against second respondent dismissed as not pressed. What about court fee?
my lord, court fee, I am not a party to the suit, my lord. My lord, I have paid the court, I have no arrears of rent, my lord. There is no damages claimed against me, my lord. I have assessed I have valued the suit for under section 41 class 2 of the court fee act, my lord.
No, you want entire judgment to be set aside, right?
Yes, my lord.
So in that event, You have to pay court fee on the value of the appeal.
But they are claiming damages also, my lord. Damages
No, you want it to
against
be
the third respondent, my lord.
So that portion you are not questioning.
No, my lord. Only against the two shops, my lord. I mean, I am a tenant of in the ground, first floor of the two shops.
They are only
my lord.
questioning the order of eviction.
Yes, my lord.
Just further ejectment of defendant along with recovery of areas of rent, electricity charges, damages. Therefore, he challenges only that.
Even third respondent also filed an appeal before this honorable court, my lord.
Learned counsel for the appellant submits that the appellant is not a party to the proceeding before the trial court where the decree for ejectment is passed and also a direction is issued to pay the damages at the rate of rupees 25,000 per month against the defendant. Learned counsel for the appellant further submits that he is only questioning the decree for eviction on the premise that he is in possession of the property. Submission is placed on record. The office objection relating to court fees overruled for the time being.
Yes, my lord.
Where is the application
I see.
for permission?
Permission, my lord. In page 48, my lord. Order 13(1)A of the commercial code act.
Any petitions there, I don't see it.
Page number, sir?
Page number? Is there?
Page number 48, my lord. 48, my lord. Sorry, 78, my lord. 78.
Awesome.
35. Because I don't have the 78 page number.
Yes.
That is not there in my.
I request the honorable
Yes.
to pass interim stay, my lord.
No, there is no decree against you.
But they are more, if the another appeal is succeeded, but I am in trouble, my lord.
Execution petition is already filed.
Not filed, my lord.
Learned counsel for the appellant submits that though the decree is passed against the defendant before the commercial court, since the appellant is in possession of the property, the decree holder is likely to evict the appellant from the possession of the property by filing the execution petition. Considering the grievance raised, the operation of the impugned judgment and decree is stayed till next date. Issue emergent notice.
Please, ma'am.
4, Tirthe Gowda.
Your Lordship, the NOC is not required for this case because writ petition is closed with the earlier advocate. They will raise the objection for the other advocates. This is a writ appeal, revision petition.
You didn't appear before in this appeal?
Yes.
You didn't appear?
Other, I am not appearing,
Who is the counsel?
the other counsel is appearing.
Should not be entertained. Specifically in.
Vishnu Hegde.
That's transparent.
Correct.
Yeah, absolutely cannot be.
Writ petition is appeared. Vishnu agreed.
What happened to the council who appeared in the appeal?
That case is closed. We are appeared before the SLP.
No, there are judgments which would say
Yeah.
that in a review petition, the same counsel who argued in the original matter, he should appear. Unless he is otherwise disabled for some reason, valid reason.
Me the week's time before taking NOC. No objection. Week's
No,
time.
NOC may not be the solution.
Even second question is delay. Second question also is there.
No, you better file review petition along with him. Probably that is the solution.
Yes, we could give me the 2 weeks time to take.
2 weeks time granted.
Step to answer the question.
5. Ajay Kumar M.
The appellant.
Was taking steps, Malats, I shall take that in the course of the day itself. Malats, Malats were pleased to grant us interim order, Malats, on 19th of April. Malats have granted us 4 weeks' time to make the deposit before the commercial court in the commercial AP number 71 of 23. Malats, we had kept the DD also ready, Malats. The 4 weeks' time lapsed during the vacations. Hence, we had moved the court on the date of reopening, Malats, and on 28th, on the very next day, we have deposited that. So just want to file a memo, my lords, saying it's in compliance with the orders of my lords. Because it was not exactly on the date of reopening, I moved that.
Okay. For the learning council for the appellant, the memo. In view of the fact stated in the memo. Memo submitted by the learning council for the appellant. The compliance of the interim order dated 19/4/24 is recorded. Memo is allowed. Yes, what about notice?
We'll take steps in the course of the day, my lords. May I additionally, my lords, may I seek permission to serve on the council who is appearing in the execution proceedings? Additionally, we'll take steps also.
Steps for serving notice to the second respondent will be taken during the course of the day. Additionally, the appellant is permitted to serve notice through the council appearing in the
Execution proceedings. Grateful.
6. Manu Prabhakar Kulkarni.
Appear on behalf of the appellant in this matter.
For respondent number 3, my lord.
My lords, I'm appearing for respondents 1 and 2. My lords, we request a short accommodation of 2 weeks, my lords, when this matter can be heard. My lords, we'll also file our substantive objections till then.
Maintainability.
My lord, yes, we will address the issue of maintainability. This is, in fact, the issue here is that the court will have to determine there is no classification as of today. Is our submission. We will make substantive submissions on that ground also.
Yes, my lords.
Because my understanding.
Which order is impugned? Which is the impugned order?
My lords, grant me a minute.
Order date 4/4/2024.
Indeed, my
No,
lords.
see, yes, it's in respect of the order of an emergency arbitrator, which is akin to a order under section 17 in our submission word. And
My lords, we have-
filed it as a commercial appeal because this is met.
My lords, we have objections to that. We'll raise our objections on maintainability, my lords, maybe kept after 2 weeks. We'll file our substantive objections as well. And my lords,
Interim order may kindly be extended.
my lords, we had given an undertaking. We can extend that, my lords. We have no
The
doubt.
learning council appearing for the respondent submits. Third
My
respondent.
lords, if it is
Third
possible,
No, I appear for respondent number 3, my lord.
I'm for 1 and 2, my lords. 1.
For the
My lords, if possible, could it be kept on the 11th, my lord, 11th of July?
correspondent 1 and 2 submits an app and the maintainability is being filed. And that the undertaking recorded on 2/5/2024 shall continue till the matter is till the next date of posting. Listed on 11.
11th.
of
July.
11th of July. my lords. Deeply grateful.
Great.
Seven. Abhinav Ramana.
And 8 are similar. Lord, maintainability office has raised an objection.
7 and 8.
Yes, my lord. Both, my lord, are same. Lord, application is filed under Order 7, Rule 10 to return the plaintiff on the ground that the commercial court has no jurisdiction. Now that application is dismissed, it is declined. Now, my lord, in the ordinary course, my lord, we will have to file a civil revision petition under section 115 of the CPC. Because if the order was made in my favor, it will have the effect of, my lord, disposing of the entire proceedings. But no, my lord, under the Commercial Court Act, please have a look at section 8. There's a specific bar to file a civil revision petition, which is why, my lord, an appeal is maintainable. Please see section 8.
If there is a bar,
Yes, my lord.
and if no appeal is provided, probably writ petition is the remedy.
Lord, in so far as, my lord, in fact, my lord, in an earlier occasion, I am given to understand, my lord, CRP 41 of 2023, a civil revision petition was filed, my lord, by some other, my lord, parties. This court has held no, civil revision petition is not maintainable. You have to file an appeal before the,
No, appeal only if the statute provides.
yes, my lord, statute provides.
Therefore, if it's not a revision and not an appeal, then it is a writ petition.
So writ petition, my lord, writ petition, my lord, there are judgments which say in a writ, my lord, I am only testing this proposition. Suppose this application is allowed, either rejection of a plaint or return of a plaint, it will have the effect of disposing of the suit. That cannot be done under 227 jurisdiction. It has to be in continuation of the earlier proceedings. My lord, the effect of a writ petition is, my lord, it cannot dispose of the suit. It can only, my lord, consider some interlocutory order whether it is correct or not. A writ petition cannot, my lord, dispose of a proceeding pending before the trial court, which is why
You also invoke 226, which you
my lord,
do it
226
by default.
226, my lord, Supreme Court has said, my lord, in Surya Dev's case, my lord, 226 is not maintainable. Yes. Lord, this question can be kept open. Now, the other question that is raised here, my lord, is
The difficulty is no provision provides for an appeal. Unless there is statutory provision, you can't file an appeal. Appeal is a creature of a statute.
true, my lord, true. True. But under 227, my lord, there are judgments which say under 227, my lord, suit cannot be disposed of. Now, the effect of allowing the writ petition,
The normally, so wording and of course there will be problem. See, in 227, you can take note of the anomaly which is there because of the section 8 and section 13A proviso.
my lord, now, my lord, against this, my lord, in lighter way, and my lord, Ramayana, my lord, I have become like Shurpanika. When I go there, my lord, they say you come here. When I come here, my lord, I am asked to go there. So, my lord, I have become like Shurpanika and Ramayana, my lord, running between Rama and Lakshmana. Please see section 13, my lord. Section 13 provides for appeal. Section 13 of the Commercial Court Act. It says, my lord, judgment or order, but then there is a proviso. Proviso is what, my lord, comes in my way.
Yes.
My lord, there has to be some order, my lord.
Probably what you can say is this application for return of plaint is not in the nature of an interlocutory order. The consequence is more in the nature of a final order, in case if it is allowed.
Yes, my lord. Therefore, my lord, I am saying 227, my lord. Therefore, my lords will have to take some view, because unless there is a judicial order, my lord, I will be only going.
The application is allowed. The application is allowed. That will dispose of the proceeding itself. So in that event, it can't be treated as an interlocutory. But it is rejected.
Because, my lord, if the plaint is rejected, my lord, it amounts to a decree. If the plaint is
It is for return, right? It is for return.
This is for return. My lord, even, my lord, where plaints are sought to be rejected, my lord, if it is dismissed, then, my lord, the normal remedy is a civil revision petition. Again, my lord, there is a bar under section 8. So therefore, if those applications are allowed.
Read section 8 once again.
Yes, my lord, I'll read section 8. Notwithstanding anything contained in any other law for the time being in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction, and any such challenge subject to the provisions of section 13 shall be raised only in an appeal against the decree of the commercial court. So, my lord, even if the plaint is to be rejected, my lord, that order assumes the character of, my lord, a decree. Under 227, my lord, there can't be a decree. That is,
No, section 8 itself provides for an appeal.
Subject to
Section A.
conditions.
no, subject to conditions, my lord, subject to provisions of.
Section 30.
So therefore, my lord, my lord, I am at my lord's hands. My lord, some solution has to be, my lord, found out.
No,
My
in
lord, I
which
am
case-
willing to assist the court, my lord, so that there is some,
In which case it is held that the retreat is not maintainable.
my lord, CRP, I'll just get that order, my lord, CRP 41 of 2023. Similar case, my lord, where there was an application for, my lord, return of plaint. That was rejected by the commercial court. Civil revision petition was filed. In this, my lord, they said since civil revision petition is specifically barred under section 8, you have to file a company appeal, commercial appeal is what?
And the commercial appeal was filed and entertained?
Yes, filed, entertained, and my lord, rejected on merits. So therefore, this.
The court didn't say that the writ petition is not the remedy.
No, the court said you file a appeal, because, my lord, normally, my lord, commercial court matters, my lord, will come before the company appeal court, my lord, because there's a commercial appellate division under the, so, my lord, I can, my lord, suggest two things. One, this question can be kept open so that the other side can also assist. Or, my lord, I will produce that order, CRP order, my lords may pass any judicial order, either saying that I'll have to be here or go there, so that once there's a judicial order, my lord, I'm entitled to a remedy.
Let me read it. Will you please place it then?
Yes, my lord, may I request it for, my lord, tomorrow? I'll place all.
No.
Because there is some urgency, my lord, in this. I'll place all the authorities, my lord.
Yes.
Then I'm at my lord's hands. Great.
9. Canada entry.
Withdraw. Yes. Appellant. And there is the number to withdraw. Waiver means there the appeal is dismissed as withdrawn. Memo is allowed, appeal is dismissed as withdrawn.
10. Ravindranath K.
Translation. That is all.
Last Friday, my lord, I heard this matter.
The matter has to be heard,
Is
my lord.
whether,
It should be passed over, my lord.
Shall be passed over.
That's okay.
Hearing on IA. Number 11. Zulfikar Kumar Shafiq.
Please, your. There is a delay of 126 days. I filed an application. If your lordships were to condone the delay, the matter can be posted any convenient day for hearing the matter. It's a review.
Notice as.
On the delay, notice is not issued.
Notice, then notice.
Notice is not.
Issue.
I'll take notice.
Notice. The application for continuation of delay.
Who's the party, see? No, this is formal party. These are
What is the error apparent?
Hello?
What is the error apparent?
I think it's about 43. My lord, my submission is that, my lord, on the last occasion when this matter was heard, the appeal was heard, I was not present before this honorable court, so I could not assist the court. Now, the difficulty here is, my lord, that this is an acquisition under the Highways Act. Now, under the Highways Act, my lord, contrary to what an arbitration should be, arbitration should commence from an arbitration agreement. Now, what happens under the National Highways Act is an arbitration is forced upon the landowner. So the provision says that if the land is acquired by the National Highway Authority, if the competent authority's compensation is not satisfactory, the landowner or otherwise, either party may approach the arbitrator appointed by the central government under the Act. So now, and the next clause says that whatever is the proceedings under the Arbitration Act. Now, I wanted to argue on the very fundamental error in that clause, being that Now, unless I sign an agreement, arbitration agreement, I should not be compelled to arbitrate before an officer appointed by the authorities.
If that is so, there must be a challenge to the provision.
No, so that is one preliminary. I will also, in case, that's what I wanted to see if there is a possibility of even amending my appeal. Because what has happened is here now under 37. No, it's under 37. That's the problem. Now, my problem is this, my lord. Now, if I go before the arbitrator for enhancement, suppose arbitrator says that no, we are not enhancing. Then if the proceedings are under the Arbitration Act, the only option I have is under 34. Under 34, the judge says that no, we have no power to enhance. So it is never a win or lose situation. It's always a lose-lose situation for me.
Can't be adjudicated in a review
Can't
petition.
be adjudicated either in a review petition or in a 34 petition or in a 37 petition. It will have to be decided on a frontal challenge to the provision. Without that, how can we consider any of these?
So that is why I have in fact diluted my ground to stick to only 34 and 37. Because I would like to see whether I can, I know it's difficult for me to keep my leg on this as well as on the other clauses. What has happened is, my lord, there are 2 rounds of arbitration. Now, under the National Highways Act, I don't see a provision which says that if an arbitrator enhances the award, now where is the scope for the authority to challenge that? Because it is their arbitrator. Now, in this case also, what has happened, my lord, there are 2 rounds of arbitration. I went before the arbitrator enhanced the award, the compensation. Now the authorities challenge that under 34 proceedings. That award is set aside and a second round of arbitration where, my lord, it is reduced to 1/10. So which means I have 2 arbitrators awards and the difference is 10 times.
You had filed wakalat in section 37 proceeding?
Yes, it's my wakalat.
You had filed wakalat?
Yes. In fact, I was absent on that day. I must admit, I was absent on that day.
SLP is filed?
My lord.
SLP filed and dismissed?
No. I thought I'll take my chances before your lords first.
You're not present on that day. Yes. Does not fall under the category of error upper.
No, I. Only thing is I could not assist the court. I feel that if I had assisted the court, things may have been a little different. That's my hope. Found hope.
Yes, notice in the delay petition is issued without entering into the merits of the matter.
12, Ramesh Anant.
Yes.
Things for consideration, condoning a delay of 30 days in filing the.
Notice is gone? Notice is not.
Notice has not.
Notice. Notice.
13, Prakash Angdi.
I appear for appellant in this case, my lord, respondent appeal, my lord, there is 26 days delay in filing the appeal.
26 days.
Yes.
Notice has to be. Notice.
My lord, seeking for dispensation of notice to the respondent number 3.
Who's 3? Respondent number.
Land acquisition officer and complaint.
Just a minute, just a minute.
Two sets, sir.
Dispensation of notice to?
Respondent number 3.
Respondent number 3 is a party.
Private party.
Private party. Is the 4th respondent who's the arbitrator? No, 5th respondent who's a special land acquisition officer.
For special land acquisition officer.
What respond?
Notice.
Apology.
14, Shashidhara.
It's on the issue arising out of section 9 proceedings, where the interim order was rejected. I came before its honorable court. In the earlier round, I have been granted an interim order of protection, but it wasn't expired. At that point of time, they were not heard. Therefore, my lords have said that before continuing further, let's hear the matter on merits first. That's why it's coming up. One of the preliminary objections raised by them is that an appeal may not be maintainable against an ex parte order refusing to grant relief. On that, I have to make my submissions today. Preliminary objections, maintainable, correct. Citations. Very.
Admission, seal number 15, Janardhan Rao Paturi.
Lord, I am for the defendants, for also the appellants.
Injunction saying that he should. But then, there is. Got to be a new. So it's. We need to use this. Yes.
My Lord, I am the advocate for the defendants.
Sir, are
who
you
are the
party in
appellants.
person, sir?
And this case is filed originally in the commercial
Are you
court.
party in person?
Sorry?
Are you party in person?
No, sir.
You're advocate.
I am the advocate. I'm sorry. I did not wear the gown, I
No,
think.
gown is invisible.
I'm so sorry, let's I beg to appear for the respondent in the matter.
Focus on the signature of the worker. Medium to physical.
I tender my apology for this. I tender my apology for not wearing the gown I brought also. In fact, I was thinking on the arguments how to deliver it. That's why in a hurry I missed it.
Years back, same thing had happened to my Lord Justice Vishwanath Shastri sitting in the Supreme Court. My lords may recollect. Vishwanath Shastri on one side, 60s and 70s, he was always a senior counsel on one side. So the judge of the Andhra High Court and retired and started practice. One of the ablest of the, he had not worn the gown. Similar like this, he had come. The junior started pulling him. Then the judges told him, no, Mr. Shastri, he's telling, yes, my lord, that sartorial elegance, is not relevant in this court. He said, we can't say all that. Those were stalwarts.
No, I recollect one more incident, just 2 weeks after my elevation. Justice Sarade was the senior bench member on the bench. He was heading some committee. He was going for interview at 3:30. I used to sit single at 3:30. When advocate came, my PS told that he is not wearing gown. I asked him, where is the gown? He said, it's in civil court.
Yes.
Yes, Your Honor. The plaintiffs have filed initially commercial OS number 446 in the commercial court. And I have represented on the defendant side. Defendant one company is Hippocampus Healthcare Private Limited, which is a Bangalore-based company. There is one more company in Singapore, Hippocampus Healthcare PTE Limited, in which defendant 2, Dr. Vijay Krishna Reddy, he is the managing director for the Indian company and the director for the Singapore company. As a managing director, he can deliver the purchase orders from India, and as a director of the Singapore company, he cannot deliver the purchase orders from Singapore company side. And the plaintiffs have contacted or transacted with the Singapore-based company, not with the Indian company. That means Hippocampus Healthcare PTE Limited, a Singapore company. Okay, that is the confusion. But also, the plaintiffs know very well that the two companies existing, they are existing, and they have transacted with the Singapore company, not with the plaintiff company, not with the dependent one company. In fact, the lower court had sent e-notices to defendant two. And gave 10 days time actually to file the written statement. I appeared as the counsel for the defendants. And then the judge gave only 10 days time to file the written statement. And this time I would not get the certified copy from the court at all. So I applied for the ordinary copy. Based on that, I prepared the written statement and submitted to the court. Now I found some irregularities and illegalities is actually not valid at all as a file to be submitted by OIR, original suit. One of the observations is their wakalat is signed by, is mentioned two names, but only signed by one person.
Just a moment, Counsel. Did you raise this contention?
Yes.
That the entity against whom the suit was filed was different?
Yes.
Was it raised in
Written statement I already
the
filed.
first instance?
Yes. I'm just reiterating for giving a gist of the actual case. Then I also argued in the lower court on 13/7 that there was no agreement at all between the two parties, as accepted by them in their plaint itself. I will tell the reference page number also in the plaint. Then I also noticed that the wakalat is mentioned as given to two advocates, but signed only one advocate without any wakalat stamp placed. Then the argument went on 13/7. I told these points. Then finally the judge asked me, is there anything actually to pay to them? Then I asked the judge, sir, are you asking me morally or legally? Then they said, morally. Okay. Then I have to say, I said I have to consult my defendants and then come back to you, sir. I said. Then the judge said, okay, submit an affidavit by next day. Yes, sir, I said. Then the judge got transferred. On 68, the judge got transferred. The next judge came upon 13/9/23 and reiterated to give the same argument. And Mr. Nipun Saxena, who is the AOR from Supreme Court, argued firstly from plaintiff side, and I argued on the defendant side. On 13/9, second time, new judge, same arguments we have. In fact, Nipun Saxena did not file any wakalat at all. Nipun Saxena did not file any wakalat at all. Then, when I referred that the wakalat filed by them is containing only one signature of the advocate, not two signatures, even the two advocate names are mentioned. When I referred to page number 198, and said, as per my records, two signatures are there. Then I got stunned. How two signatures are there? Then immediately the judge by next date, 8/1/24, he gave the order on the IA1, IA2, IA3. Then I reapplied because there was no time actually for me to apply for the certified copy of the claim. I asked for the ordinary copy and I have verified page by page myself, and I also submitted the first time copy what I have taken from court, and of the second time court after the judgment is given, after the 13/9/23, that copy both. And then I noticed that in the important pages where the court has put the received seal stamp, those pages are substituted to this honorable court through the appeal. Then the placement of the stamp, received square seal, is differently put in different position, and also same 1/4/23 date is mentioned. That means there is a fraud played on the court record between the date.
If you feel that some records have been tampered before the trial court or commercial court,
Without the
you move,
permission taken.
just to move necessary application for the said court. Said court will take action if it is warranted.
But the judge got
No,
transferred.
you can argue the case on merits.
Yes, what is your argument on the merits of the matter?
That is one fraud they have played, and also there is no agreement at all between the two companies as agreed by them in the plaint themselves. Okay, agreement was circulated, but no signed thing is never received, so there is no agreement. it is only, they also confirmed that the transactions they have done only on the understanding basis, oral understanding basis, they have sent the goods.
Their
to the-
contention appears to be that it has all been, there are email communications.
Statement
which-
of all these things.
That is what the court says.
And
Email
then still-
communications.
And they have applied the PIM also under section 12A. Wantedly, they have this avoided by saying that no, they have sent the goods, we have sold the goods, and we have not paid the monies to them. In fact, that is not the fact. We never sold it. And I have submitted the bank statement also to the lower court and to this court also in appeal that we have not received single paisa from out of the sale of that goods, and which is not correct. Based on that, they have avoided the PIM, pre-institutional mediation kind of thing, which is not correct. It is not, in fact, this case is not maintainable. And also, they claim that they find the original suit
Supposed to be sent some Singapore. Why did you?
Also, they claim that they find the original suit under 21C18 section of the Commercial Code Act 2015. When I opened that section, it says agreement and services. Okay, but there was no agreement. They only are agreeing that there's no agreement. Then that section is invalid. And it
Oral
documented-
oral agreement is recognized under law.
Sorry?
Oral agreement is recognized under law.
So, but the
Agreement need not be in writing.
But oral agreement also is not there. Oral agreement is also not there between the parties. Right, sir? So that section is not applicable. And the case is not maintainable. And the commercial court doesn't have the jurisdiction to take up that case at all. And they also calculated the interest on top of the invoices. But invoices, they did not refer the purchase order reference number by the defendants. They referred the procurement order, what they have procured material from third party, that procurement order reference number they have mentioned in the invoices, which is not applicable to us. In fact, the defendants have not have to pay in all aspects, no agreement, no invoice containing the purchase order reference number, nothing. And they have escalated this thing, including the 18% interest as per section CPC section
34.
12A2, I think. Yes, sir. It is 2A2. TPC Order 7, Rule 2A2, which says when the plaintiff seeks interest, the plaintiff shall state whether the plaintiff is seeking interest in relation to a commercial transaction within the meaning of section 34 of the Code of Civil Procedure, 1908. And furthermore, if the plaintiff is doing so under the terms of a contract or under an act, in which case the act is to be specified in the plaint, or on some other basis, and shall state the basis of that. That means without mentioning anything for 18% interest charging in their tax invoice, or according to which law they are charging 18%. They have just escalated the dollars by 18% interest and then came up to 12 crores, 35 lakhs, 21,175 rupees. And the lower court, and the new judge had come up. Then he ordered to pay this much amount by through the order on IA1, IA2, and IA3. IA1, IA2, and IA3 are for the declare the assets. IA2 is for the non-alienation of the assets. IA3 is to deposit that amount. So on the IA1, IA2, and IA3, the court gave an order to pay that much amount, 12 crores, 11 lakhs, that amount, or show bank guarantee. In fact, the lower court in their order have mentioned the wrongly applied the Mavera injunction. The lower court had wrongly applied the Mavera injunction order. In fact, I digged out what is Mavera injunction, and there are three pillars for the injunction. The case is there should be a prima facie legality. There is no agreement at all. How it can be a legal thing? The oral agreement is also not there. Then only on understanding basis and assurances given basis, they have supplied the goods. Then the second point pillar is balance of convenience. Whatever under which section, whichever sections they are claiming, 21C8 CCA is they did not file under that at all. So balance of convenience has no role play at all. And the third one, the pillar on which the Movera injunction is standing, no irreparable loss and harm was ever caused to respondent. That is the third pillar. In fact, because of the wrong supply, because of the defective product without certificates and without certificates and then late and then demurrage charges we have incurred, we have paid $52,000 and also $19,000 bondage warehouse charges. And then our company lost credibility. In fact, they have not supplied the correct goods, they have goofed and then deceived the defendants because they have not packed the correct number of gloves. And by weight, sampling when we have done, all samples show different weights. That means the packaging is a problem. They did not put the correct number count of the gloves in the boxes. And our company lost the credibility by supplying samples to our clients. And we have asked them to take back the goods. They never replied. And the principal commissioner of customs is on our head from by his letter dated 30/1/24 to pay pending charges. That means because of their cheating in the goods and because there is no agreement and they supplied false goods and then quantity was less, all defects they know and they don't want to open the PIN. That is why they falsely avoided the PIN and then the fraud. With fraud, and this is not a valid, let us say, petition at all of a original suit at all filed in the court. So based on that, I came to the appeal court and then with a request, I also asked for a stay order staying the petitions in the proceedings in the lower court until the appeal is finalized by this court. So this is the gist of the case actually, and there are intricate points which I have noted. Maybe the court, if it permits, then I'll go point by point and prove the case myself. So with this, I think I have given the gist of the case. The purchase orders also very sure I have listed out the purchase order number is in the purchase order.
Interest is not yet awarded. Figure is only for this. Also includes 18% interest.
Yes.
Yes, may please. May I just first indicate what is the dispute all about? The respondent before your ladyship and before your lordships is a German-based entity, which is a reseller of nitrile gloves and oximeters. Now, the plaintiff entity, which is the appellant before your lordships, is an Indian-based company, a Bangalore-based company. There are two very important dates which I would place for your lordship's consideration. First is 16/4/2021, and second is 26th May 2021. Now, both these dates are very material because they are the dates of the purchase orders which have been issued by them to us. In terms thereof, when I say them to us, I mean Hippocampus Private Limited, because my learned friend has filed his appeal. He has not placed those purchase orders on record because those purchase orders indicate at 7 places Hippocampus Private Limited through Shri Dr. Reddy, who is defendant number 2. Now what happens is, on that understanding, we say this is the confirmed price, this is the FOB, and on that basis, we deliver the shipment. While the shipment was in transit, they made several changes to the consignee names, etc., but I'm not going into that. What is material is that their payment obligation was triggered within 30 days from the date on which the products were delivered. Now, the products were delivered, the oximeters were delivered by 16th of June, and the nitrile gloves were delivered by 30th of July. Their finance director writes to us saying, yes, we are aware. We have to make the payment within 30 days time. Please give us 2 days more to make the payment. We said, very well, no problem. Take your time. Also because it was COVID going on. So we thought it's all right. Let's give them some time. They say that we are standing in front of a bank. We have specifically pleaded, their email correspondences are all there. They have acknowledged the debt on 17 occasions, and none of those emails have been produced by my learned friend before the appellate court. They have also indicated that they have already sold all the goods to their network hospitals. So now I was left in a lurch because not even a single penny from 30th July 2021 till present date was paid to me, and all the goods were already sold off. So therefore I was constrained to file a civil suit, and I also filed 3 interim applications along with the civil suit. The first interim application, was deposit only the principal amount. I'm not claiming interest. My learned friend was alluding to several provisions of the interest. I'm not going into that. I said, please, for the purpose of this.
$1,180.
Yes,
it's not inclusive of interest.
Yes, it's not exclusive. In fact, I'm so grateful for that observation, because at page 102, page number 207 of volume number 2, the learned trial court, the learned commercial court, I'm so sorry, has reproduced that at paragraph 18. And that amount is in US dollars. I'm so sorry, my lord.
Yes.
Yes, at page 207, para 18, that amount.
Entire consignment is issued by them?
Yes,
Entire consignment.
I'm so deeply grateful.
Nothing is lying in the port?
Nothing,
Why are you seeking demurrages?
I'm so sorry,
Why are you seeking demurrage?
No, I'm not seeking demurrage. I'm only seeking my principal amount. I'm not seeking any of those things. Now the title in the goods passed over to him as soon as the goods were delivered. Since it was on FOB basis, every single charge was to be borne by my learned friend's client. Now, if they are incurring any other charges for whatever reasons, it's not my fault, because the title has already transferred to them. And they have not shown their bona fide even for a single day from 2021 till 2024. Not a single penny has been received,
If there is a direction to deposit the amount.
Yes, in terms of the IA number 1.
There can be one more direction not to alienate any of the properties.
Yes, because I'll tell you, why that happened. While we were in the process of filing the suit, we wanted to file an application under Order 33 Rule 7 for attachment prior to decree, because we were afraid as to what properties do they have. When we inquired from the jurisdictional sub-registrar, we found out that the property that they claim to have is not even theirs. So today we were left in a lurch as to the goods not being with us, the properties that they claim are theirs are not even theirs. And so therefore, the requirement of pre-institution mediation on the very first day was dispensed with by the learned commercial court.
Not the question.
Yes.
Once there is a direction to pay the entire consignment amount, why there should be a further direction not to alienate any of the properties?
The direction, was only limited to depositing in the court.
Look at the impugned order.
My lords.
There's a further direction.
I believe this is referring to page 231, which is IA number 2. The defendants or any other persons under through them are hereby restrained by way of an ad interim order of temporary injunction from any manner whatsoever, directly, indirectly alienating, selling, transferring, encumbering, dissipating, mortgaging, pledging, creating lien on movable or immovable, tangible, without limitation, their respective shares, mutual funds. And third one was to disclose on affidavit what assets do they have. That's also a third prayer.
They're seeking a restraint order to such an extent that they can't even sell their own products.
May I make a concern? I see what is falling from your lordships. If they are willing to
they have to virtually shut down their operation.
But what I'm suggesting, for your kind consideration is, if they are willing to make the deposit, we will not press for this, and your lordship may suitably modify the order. But at least let them deposit, and also disclose on oath the affidavits, Millets, because what we are running under the assumption today is that they are a fly-by-night operator, and Millets may only consider their recitals in the WS, in addition to making scurrilous allegations against us, which I am not getting into, Millets. At least kindly look at the allegation that they have made in the WS, Millets. I'll just show that. Let's at page 167, your lordships would have the WS, Annexure G. Let's may only kindly come to page 169. I'm sorry. Top, somewhere at the top, let's A, the said PO dated 26 May 2021 was seen as signed by defendant 2 as the director of the Singapore based entity without having any such power to sign the said PO, Mullets, comma, and also seen as signed director for India-based company without having such power as its director. When we checked up with the records of the MCA, it is shown that he's the director of that company, Mullets. So he can't be made to approbate, reprobate, and conveniently use the Singaporean entity as a shield just to evade his contractual liability. And Mullets, on a commonsensical basis, Mullets, I'm willing to let go of everything else. The Indian entity places the order. Goods are delivered via Vishakhapatnam to Bangalore. They are placed in Bangalore, and the goods were sold by them as per the director of the Bangalore-based entity. So today, perhaps it does not lie in for my learned friend to argue that it was some other entity which has cropped up. There's only one last submission. Let's at page 224, paragraph 57. Para 57. Under IA number 1, it's not that I have sought only deposit of the actual amount. I have also said or furnish suitable security by way of bank guarantee till the disposal. So I will be protected even in that respect, So I understand, we have to be also pragmatic about their operations. So I am
They're allowed to operate, probably they may generate.
I am deeply grateful at least, but I mean, experience has shown that this is not the case, at least for the last 4 years. So may only balance the equities, is what I'm requesting your lordship to consider.
They request you to give me permission to talk about the purchase orders. They are defective, they are not released by my company, and they are transacted with those purchase orders with Singapore company. We are not liable. Give me just 1 minute. I will just refer to page number 71, the purchase order. What are defective purchase orders not placed by our company. Oximeters, document, which is or signed by defendant 2 on behalf of Singapore company, sir. PTE Limited, Hippocampus Healthcare, PTE Limited is Singapore company, sir. That purchase order is never raised by Indian company, private limited.
Did you send back the goods?
We in fact sent them a mail. They did not reply. We have to hold it in the customs. We have to pay the demurrage charges for that. They did not reply to accept the delivered goods back to them. So what we should do, sir?
Once you received the communication from them stating that the goods have been dispatched, did you immediately respond to them saying that you have not placed any order?
We didn't say that, not placed any order, but see, on an understanding basis, they said they supplied the goods.
If you had not placed the order, what should have been your natural reaction? If somebody dispatches goods worth several crores or several lakhs, and if you are saying that you have not placed any order,
we thought
what should be
Singapore company and an Indian company.
What should be your reaction?
In fact, we have not noticed that until they filed the case actually, And we said we cannot pay that amount because it is defective, it is 420 cases, there is no defective.
No,
Goods are also not placed.
No, saying defective is one thing, not placing order is another thing.
Then we have not placed the order and then the shipment address, it's only Indian company. Sir, the shipment address is only Indian company.
And your
Order is
content,
not placed.
your stand is probably your customers didn't pay you on the premise that they are defective goods. So you didn't incur
We
any,
sent only samples. We sent only samples to our customers.
if you have not placed the order, what made you to show the samples to the customers?
So we have receiver address is ours only, right? The dispatch address is only ours address, Indian address only. But that's not correct, sir.
Take it and send samples.
PO is not placed and they are invalidly applying that PO and then our purchase order also is not referred in their invoice at all. How can we relate and then how can we pay, sir? And then second invoice, not issued by defendant one company, no existence of contract. Second, I refer to page number 92, sir. Second purchase order. And it is sealed, put the Singapore company seal is put. It is not the Indian company seal. Kindly see, sir. And he is not the defendant 2 is not the managing director of Singapore company. Okay. Then, but that PO is got mail attached and delivered by somebody else. Then the seal of Hippocampus Private Limited Indian company seal is not put on the purchase on the PO. Then also, it is first signed by someone else other than defendant 2 as managing director for Singapore company. And that purchase order is not valid. And also, the valid Indian company mail address as for them with the MCA is different than what mail ID is sent. Page number 60 of the plain. Sir, page number 60 of the plain. Sir, as per 60th page number of the plain, the official mail ID of our company is put by them in the plaint itself. That is page number 60, vijay@hippocampusinfodec.com. And that is the official number. But different mail ID is, they are transacted. So that is not belonging to the defendant company at all. And once the so-called alleged purchase order was placed, they should send a free consent actually accepting the terms and conditions and also payment terms. They did not send any free consent. That means agreement is not formed between the two companies. So, and also in the alleged PO, there is a sentence that our company wishes to issue PO. There is no firm order placed at all with the purchase order, so-called alleged purchase order. Then the plaintiff agrees. It is pertinent in the plain page number 30.34. Very important, sir, this one. Plain page number 13.34. Just read out the paragraph.
That your lordship would be pleased to find at page 130 of volume number 2, which my learned friend is alluding to.
Appeal, I have also enclosed that one.
Yes.
34 point, I have, as it is text-wise I have put in here. It is pertinent to mention that although proposed sales and purchase agreement was only a draft agreement and was not signed by the parties, the purchase order dated 16/4/21, however, clearly encapsulated the requirements of delivery in terms of the purchase order dated 16/4/21, which was agreed to the following. That means they themselves are accepting that there was no signed purchase order at all between the two parties. And there was also one agreement was not acceptable, not agreed between the two parties. And one more point is that it is on page number, page number 14.35. They are only accepting. I read out the text. On the strength of these assurances, the plaintiff was made to believe that the defendants are trusted players in the market and are serious about their commitments. One more point, sir. Plain number 23.58. It is pertinent to note that through the proposal sale and purchase agreement dated 16/21 was circulated between the parties, the same was not conclusively executed by the parties, since the plaintiff never received a signed copy for the same. Come on, there is no agreement signed at all. Orally also they cannot prove, they did not have, only on the understanding basis they supplied the goods. In fact, I give my mail ID to give them to supply their understanding basis. I will sell off their goods at higher prices, at defective prices, and also less packed per box. Okay, sir?
Yes.
And this commercial court simply accepted the original suit and then gave the order on the IA 1, 2, and 3. Give a bank guarantee, including the 18% interest, which is never spent out by them through any law in the original suit at all. And we are not, and our company is going to ditch. We cannot, they are not allowing to take back the goods, defective goods, and they are charging us that they know very well the products are defective without CK certificate and without proper loading into the boxes, the number of gloves is per box. They cheated, they deceived internationally, and we lost the credibility before our clients. So I request this appeal to be admitted and then pass stay orders to the lower court until this appeal is decided by this honorable court.
Sir, I'm so sorry, Melissa, just one intervention. That's page 124, para 16, because my learned friend is now building a defense that somehow the products did not conform to the quality or quantity.
Yes.
Page 124, para 16, their director writes an email. I'm so sorry, I'll just read it, Milits. Defendant number 2 with an email dated 14/5/2021 at 6:01 p.m. reconfirmed the order and clarified that there was no misunderstanding between the parties. Further, the said email of reads as follows. We are going with the order for 20K. The oximeters, which you have shared, is a high-end spec with good quality and features, and we want such quality products to be supplied for our network hospitals. Thereafter, Milits, we also carried out a third-party inspection from US-based entities and Thailand-based entities. And all those documents were part of the plaint, which my learned friend has not annexed. So it is too late in the day to argue. When we call upon you to make the payment, then you come up with these post facto explanations.
So many boxes were, let us say, they have sent. And we have taken the samples to send to our customers.
Understood.
The samples do not carry the correct number of contents. That means they have cheated. We got the credibility, we lost the credibility in front of our customers. How can we pay them?
No, samples are not to the specifications ordered by you, right? Yes.
Not ordered by us. In fact, not ordered by us, as per the purchase. The so-called alleged purchase order. It's not ordered by dependent one company, sir. Very important thing.
Then why are you complaining about the quality of the samples?
They asked us to somehow sell it out. They asked us to somehow sell it out. Then we took the samples and sent. This is the defect, and we cannot send them back. They are not accepting. We cannot sell it to the clients. We are in the fix, and they are charging. They are filing the case to recover the full amount along with interest.
In fact,
this is not the, and they have misrepresented the court also. Falsely, they have misrepresented the facts to the court.
Yes.
Yes, sir.
Melissa, on Wakalat, do I need to satisfy your lordships, or I mean, because the Wakalatnamas were duly filed, duly signed, the certified court copy is already.
When the Wakalat also, the lower court. You can see page numbers also 95, 198. Both sets are included to this appeal, in this appeal.
No, those things can bring it to the notice of the commercial more appropriate application.
They are already given the order.
No.
Not verified. What I'm
That is,
saying.
if the tampering of records is found, the appropriate commercial court will take appropriate action. You file an application.
Further, sir.
No, you move the court, let them respond.
They have proceeded further. They gave next day. They are asking for, let's say, other documents to submit, and they are not listening to what I am saying. That's fraud. That's unless you see bring the original, let's say.
Invoke appropriate provision, move an application, let them respond, let the commercial court.
In fact, I have already sent it. They have not responded. They filed writ actually. Instead of replying, they filed writ in this court, in this high court. So that ensures that they don't have
let's-
things to say.
I think what I have to say is this, minutes from annexure J, which is the annexure J all the way to annexure I, never even formed part of their WS. This is for the very first time they are taking these grounds in appeal, Millets. No order 4127.
One thing we have to say, prima facie,
My lords.
if only one advocate has signed wakalat.
Yes,
when the appeal was, suit was filed.
Yes, sir.
And at a subsequent date, if one more signature appeared on the wakalat,
My
it's a serious matter to be taken.
Yes, yes, Millets. Millets.
Not have been done.
Yes, Millets. My briefing
So
counsel.
that
Yes,
there may be
my
proper
clarify,
application by the other side.
Yes, Millets. My briefing counsel will respond, Millets.
At the most, you could have filed one more wakalat. You could
Please,
not
my
have put the signature on the wakalat which is already filed before the
If I
court.
may clarify, my lord, we filed the plaint in two sets, and in the first set, both the advocates have signed the wakalat. In the second set, one of the advocates' signature is missing. Even as on that, the courts file as both the signatures in one set of the wakalat and one signature in the second set. They have procured the copy of the second set of the wakalat and they are making these allegations, my lord. No, sir.
It was
all right.
Before they will file the case, and 13/7 when I taken the copy, second wakalat signature is not there. By 13/9, second wakalat signature is there. So that means
Appropriate application before the commercial court.
commercial code, that's why I came to appeal, sir.
No, sir, on that allegation relating to tampering of wakalat and all those things.
I find, sir, but the judge got transferred. New judge came up.
Whatever,
And
sir.
he is proceeding further.
He has to pass an order on that application.
Yes, I'm so deeply grateful for a very patient.
I'm dependent on this appeal court only, sir, to take care of such fraud and then give me proper
Yes.
orders.
Yes.
I can't go anywhere and lower court is already progressing. And further, whatever it has progressed, I have responded. And then for writ against that.
Yes.
So there's a stalemate situation. I think the honorable High Court only has to resolve this case. This fraud is to be.
Yes.
So I'm grateful for a very patient. object.
Because a stay order, sir.
Go to the announcement.
Just check.
Delay.
Item number 3.
Verification only seeking the challenge against the eviction. Areas of. Tomorrow, let it be listed tomorrow.
Let it come to me.
With the Commission overruled along with application of condemnation.
Sixteen urgent, 17, Tejasvi KV.
Appellant's counsel.
The appeal arises out of section 9 proceeding, but I'll try to simplify because there are so many litigations and all that, but I'll try to simplify. Respondent number 2 is my sister. Respondent number 1 is my brother-in-law. Admitted situation is that in the year 2024, myself, my brother Millard, who subsequently died in a bomb blast in Sri Lanka, and my sister and my brother-in-law, 4 of us constituted a partnership concern called Harsha Hospital on Nelmangla Road. The shares are divided 30%, 20%, 30%, 20%. This is not in dispute. Then subsequently in 2004 itself, we purchased about 1 acre of land. In the name of the partnership concern, the amounts were paid from the partnership account. Now, this is also not in dispute. Now, about 97,000 square feet of built-up area was constructed in 3 blocks in that 1 acre of land, out of which some portion is used for hospital. Now, my allegation is subsequently a charitable trust was created by my brother-in-law and my sister. In that trust, we were inducted and we were thrown out. That's a different issue which is pending before the civil court. We are not concerned with the trust.
You are a party to the trust deed?
Yes, yes. We were inducted in the trust. Subsequently, we were removed. Both the brothers were inducted in the trust and they were removed subsequently. There is a litigation filed by the trust against the hospital and also the partners not to dispossess them. There is an injunction granted against that. Appeal is pending. Therefore, so far as the trust is concerned, that is nothing to do with the present proceedings. Now, in the year 2007 and 8, 3 lease deeds was created by
the the first respondent, my brother-in-law, giving about 56,000 square feet out of 97,000 to the trust as a lease, which according to me is totally illegal because I did not sign. My deceased brother's signature is found in the lease deed. They are claiming that they are the lessees about 56,000 square feet out of 97,000 square feet. In that, my lord, according to me, 3 educational institutions are operating. One is Harsha International Public School, Pavani Nursing Home, and 2 more nursing homes, where in the remaining area, out 56,000 square feet, they are claiming. In the remaining area, admittedly, Harsha Hospital is run by the partnership concern. Now, this hospital is shown as a parent hospital for the purpose of obtaining lease and the permission and all. So, according to me, even the CBSE was defrauded, all sorts of illegal activities going on. So far as the educational institutions are concerned, we are not concerned with that as of today. All that I am asking is, I have triggered the arbitration proceedings for dissolution of the firm. Admittedly, we are the partners, the property belongs to the firm. All that we are saying is, please do not encumber the firm properties. Because what they have done is, these lease deeds which have created in the year 2007 and 8, leasing 56,000 square feet, is without my consent, that is Mr. Shukumar. My brother's signature is found, that is a serious dispute. Now today,
This is by the trust.
in favor of the trust by the firm.
By the firm.
By the firm. I am not a signatory. What they are doing, under section 12 of the Act, Partnership Act, majority we have to take a decision. Under section 19, that is 1G, a partner cannot encumber the properties. A partner cannot encumber the properties. It has to be by a majority decision under section 19. A partner cannot transfer immovable property belonging to the firm. Under section 12, your lordships are aware, every partner has a right to have an access and inspect a copy of the documents, and we have a right to be participate. We have a right to participate in the firm. So I'm simplifying from what was transferred before the trial court. Today, what I'm submitting before lordship's kind consideration is, let them not encumber the firm properties. That is our 97,000 square feet of built-up area and 39 guntas of the prime land. So far as the bank account is concerned, it was frozen and the learned single judge granted interim order permitting the firm to operate. They are operating the bank account. They are, as on today, I am not getting a single rupee from the hospital. We are not getting a single rupee rent out of 56,000 square feet. Admittedly, both the first and the second appellant, first appellant is the brother, second appellant is dead and the legal representatives are on record. Respondent 1 and 2 are my brother-in-law and sister respectively. They're running the show. All I'm saying today, before your lordship, is let them not encumber the firm property. Now the trial court says, no, you suppress the suit against the trust. You suppress the writ petition where there is a permission to operate the bank account and all. We are not concerned with the trust because we were part of the trust. We are removed now. We were part of the trust and we removed. Now the trust has 56,000 square feet and they are running all sorts of educational institutions.
Injunction order is operating another suit, which the trial court says that you have not disclosed. Does it operate in respect of all the property?
No. Well, what has happened? Admittedly, in the suit, they quote 3 sale lease deeds, which are dated 19/1/2007, 19/1/2007, and 2000/2008. In that, my lord, 16,000, 20,000, and 20,000 square feet was leased to the trust. Now, in the suit, this is not the area shown. What is shown is entire 39 guntas which belongs to the firm. Suit for injunction which is filed by the trust, they do not say about the built-up area. And
so that covers entire 39 guntas.
Entire 39 guntas, there is an injunction order not to dispossess them and not to interfere with their possession. Absolutely no problem. We will not interfere with the trust activities. We will not interfere with the educational institutions at all. Let them even operate the bank account. Let them not encumber 39 guntas of prime property and 97,000 of built-up area. That's all to the limited extent. Other aspects.
Why was this not disclosed in the suit?
Blood, that is to do with the trust. Blood, what happened is this, blood. In the suit, they filed a suit against us saying that they are the lessees in respect of 56,000 square feet. We should not be dispossessed. There was ex parte injunction order. We filed objections and contested injunction is confirmed. The appeal is pending before the trial court. And in the writ petition, they were the bank account was frozen. Now they are permitted to operate the bank account. The trust property is concerned, we have absolutely nothing to do with the arrangement, so far as the trust and the educational institution concerned, except saying that they're all illegal and that's a different thing. And in the suit itself, my lord, there is no identity of the property. Identity of the property could have been the lease property, that is 56,000 square feet. What they've shown is the entire 1 acre of land, not, this built up area is not disclosed. The suit has to go, that's a different thing, we'll argue on that. And one of the lease is in favor of my sister, individual name, nothing to do with the trust. 16,000 square feet of lease is granted in favor of my sister and not as a trustee. There are two sale deeds, lease deeds in the name of the trust. They are likely to be in possession of property. My lord, we will deal with that later. Today, the immediate, my lord, your lordships are aware under
Session
section.
has not yet commenced.
But pardon? No, it has not come. There was a mistake in initiating the arbitration proceedings, and the matter came before the Honorable Court for appointment of the CMP, appointment of the arbitrator. There was a mistake committed by us. Therefore, we have taken the liberty to file a fresh CMP. That, my lord, your lordships are aware. The strict principles of 13 rule and rule 2 will not apply. The whole idea is to preserve the property till the arbitration. We have sought for dissolution of the partnership concern. We have sought for about 44 crores. Admittedly, 4 partners are there with 30, 20, 30, 20, and the property belongs to the firm. This is not in dispute. So therefore, my lord, section 9, it's only the preservation of the property, suit for injunction, the 39, 1 and 2, my lord, that rigorous application of the provisions, my lord, is not permitted as per the judgment of the Honorable Supreme Court. All that is required is till the matter is adjudicated by and the most innocuous prayer I'm seeking is let them not income, because we have 50% share. We have a right to participate, and the Partnership Act itself says that they shall not deal with the property. Kindly see, my lord, one clause in the partnership agreement. My lord, kindly see the partnership agreement. Page number 357.
Firm is not dissolved.
Pardon?
Firm is not dissolved.
No, not. 357. This is borne out from the order of the learned judge himself. Your lordship got 357. No, that's not visible. This is okay. Lord, the share, Shivakumar, that is the first appellant, is no, the second respondent, first respondent, 30%, my sister, 20%, the first appellant, 30%, second appellant, 20%. Now, the contribution is also mentioned in 49, but I will draw your lordship's attention to one line in the partnership deed that your lordship get at, my lord, clause number 10 of the partnership deed at page number 48. Page number 48, my lord. Your lordship got the partnership deed. 48. Page number 40. Kindly go to, my lord, next page number 49. No partner, clause number 10. No partner without the consent of the other partners in writing shall have a right to sell, assign, encumber in any manner his or her interest in the business of the firm. Apart from that, my lord, section 19 of the Act, Partnership Act, section 19, subsection 2G.
Yes.
Section 19, my lord, subsection 2G. The authority of a partner to bind, my lord, subsection 2. In the absence of any usage or custom or of trade to the contrary, or the implied authority of a partnership does not empower him to G. transfer immovable property belonging to the firm. Then section 12, my lord, of the Act. the conduct of the business, subject to contract between the parties. Every partner has a right to take part in the conduct of the business. Every partner is bound to attend diligently his duties to the conduct of the business. Any difference arising out as to the ordinary matters connected with the business may be decided by a majority of the partners, and every partner shall have the right to express his opinion before the matter is decided, but no change may be made in the nature of the business without the consent of all the partners, and every partner has a right to have access and inspect the copy of the books of account. My lord, we, as on today, my lord, we have nothing to do with the trust. They are claiming to be lessees and the matter is pending before the civil court. The bank account is concerned, they're operating the bank account, absolutely no problem. We'll bring it to the notice of the civil, learned single judge. All I'm saying is 39 guntas of land belongs to the firm, 97,000 square feet built up area belongs to the firm. Whether whoever is in occupation of the property, my lord, the arbitrator will decide. The Harsha Hospital is in possession of the remaining extent of land. Let them not encumber the property.
Out of 39 guntas, how much is with the trust and how much with the partnership?
56,000 square feet. There are 3 lease deeds executed by the lessees to themselves. This is, my lord, this is very interesting. 19th of January 2007, 16,000 square feet to Girija. That is my sister. It is not to the trust. Now the trust has filed a suit for injunction, not Girija. Then on the same day, another 20,000 square feet. And next day, the 2/1/2008, 2/1/2008, next year, another 20,000 square feet. Totally 56,000 square feet is in their possession according to them. The total built up area is 9.
Pursuant to the lease deed executed by the partnership firm.
No, the lease deed shows it's a partnership firm. I did not sign. It has the signature of my deceased brother and they themselves.
Right. Allegedly it is by the partnership firm.
Yes, yes, it is shown as, my lord, it is shown as the partnership firm. And
One of the partners has not signed.
Majority have not signed. I have not signed. The
Out
first
of 4.
appellant before your lordship has
Out
not
of
signed.
4. Out of
There are 4.
How many have not signed?
2 have not signed. My lord, 2 have not signed.
All 3 deeds.
My lord, page 108, my lord, just for ready reference, page 108. This is Shivkumaran. This is myself. This is myself. This is appellant 2 is dead. My lord, kindly, my lord, lease deed. It is at page number 108, dated 19th of January 2007. In that, my lord, left hand side Girija is a lessee herself.
Who, one of the partners.
One of the partners.
Who has signed it?
This is signed by Shivkumar. I know.
All right.
Second respondent as well as the second defendant as well as the.
2 lessees have signed for themselves, acting as a lessees and also acting as partners. Shivkumar and Girija are husband and wife. They are claiming to be the lessees for a trust. Now, if the lessees are excluded, the only person would have been the deceased partner. My brother.
Your brother signed it.
Yes. That it has the signature that.
You didn't sign. You didn't sign.
I did not sign.
All the 3 deeds.
Yes, all the 3.
All the 3.
All the 3. Now, those 2 signatures of S. Shivkumar and Girija are in the capacity of lessees. They are not. They may say that we are playing 2 roles.
Represented by partner Shivakumar and.
Yes, Shivkumar is my brother-in-law.
Kumar is a lesser.
Yes, Shivkumar is my brother-in-law, respondent. H. Shivkumar is my brother. I'm sorry.
Is the lesser.
Any resolution passed by the partnership firm?
No.
Entering into
No. Lord, absolutely no authorization whatsoever. And in the suit for injunction, this built-up area is not shown. What is shown is the entire 39 kuntas, no identity.
Just a second.
Yes,
3 lease deeds were executed in favor of Girija.
But 1 lease deed in favor of my sister in her individual capacity. 1 lease deed of 16,000 is.
Secretary.
Let the first lease deed is in favor of my sister.
Understood.
And she has not gone to court. The two lease deeds are in favor of Srinivasa Charitable Trust. Again, they were the trustees, Girija and my brother-in-law. We were included, inducted, later thrown out. No, these two, all the three together constitute 56,000. This is not the subject matter of the civil suit. What is subject matter of the civil suit? The land, 39 guntas. The built-up area is not shown.
So one leased in favor of the partner, another two leased deeds in favor of the trust.
Trust.
And you are not signatory to any of the lease deeds.
I have not sent to.
The second lease deed, who is the,
Second lease deed.
who is shown as a lessee? Srinivasa Charitable Trust.
Yes.
Represented by its secretary, Shivakumar S.
Yes,
son
that's
of
my brother.
Siddhalingappa.
That's respondent. There are two Shivakumars.
H is given to us.
Let,
He is the lessee.
there are two Shivakumars.
First is the lessee.
My name is also Shivakumar. My name is also Shivakumar.
With you as a signatory.
No.
In the two deeds. Yes, that is how it
There
is.
are, no. My name is H. Shivakumar. His name is S. Shivakumar. My brother-in-law is S. Shivakumar.
The other way around.
Yes.
He is H. Shivakumar.
No.
Your brother-in-law.
My name is H. Shivakumar.
You are H. Shivakumar. Are you sure?
My name is,
Then you are-
I'll come to that. Kindly
Then you
similar.
are the lesser.
My name is H. Shivakumar, who is dead now. Represented by the legal representative, as Mr. Holla pointed out. The other one is Prakash. Kindly similar to cast title at page.
Alive.
Pardon, Prakash is alive.
Alive.
Prakash is alive.
Both the Shivakumars are no more.
One Shivakumar is no more. That is H. Shivakumar. He is no more. His legal representatives are on record. Yes, Shivakumar is my brother-in-law, who is married my sister. He is alive. He is the person who is running the show.
Sister and brother-in-law are alive.
Pardon me?
Sister and brother-in-law are alive.
This is a family dispute where they want to take over the entire firm properties.
Sir, hospital partnership concern represented by its partners, Shivakumar H. To the lessee, Srinivasa Trust, represented by Secretary Shivakumar S. How do you say that? You are not a signatory, you are the lesser
In
all the three deeds.
Well, I pointed out the signature, 1 minute, sir. Signature of my brother is found. My signature of my brother is found. That's why I submitted. Signature of my brother is found, but I am not disputing that.
All the three.
Signature of my brother is there. Deceased brother's signature is shown. It is shown. I immediately pointed out.
All the three.
Yes.
These deeds, the lesser is shown as Harsha Hospital, partnership concern represented by partner H. Shivakumar.
Yes. That is not in dispute.
No,
That-
so appellant is a party to all the three deeds.
Appellant, Malad, he is no more now.
Correct. Appellant or
Yes.
LRs.
Malad, for the time being, we are not disputing for the time being. Because there is an injunction order operating against
What
us.
was the prayer in the section 9?
Malad, this is that they shall not unilaterally take a decision in respect of the firm properties. That's all we are
Their
asking.
properties,
Yes, section 9.
including these properties which you as lesser have handed over to the trust.
Malad, I'll come to
The finding.
kindly similar to application is at page number 323. 323 is the application. Where is the schedule A, B, C, L, E. That for the reason stated in the accompanying schedule, take out the schedule. At 323. Your lordship got the application, Miller? ये ಯಾವುದು? ಎಷ್ಟು ಪೇರು ಹೇಳಿದ್ರು? ಒಂದು ಸಾರಿ. Lot 323 is the application.
Yes, the prayer
Yes, ma'am.
portion is,
323, for the reasons stated in the accompanying affidavit, Assembly submitted that be pleased to pass an interim order against the respondent, the agent so and so, so and so, so and so, so and so, from taking any unilateral decision with respect to the day-to-day affairs of applicant number 1, that is the partnership concern, including but not limited to its financial management, bank operation, firm operations, its dealing with the schedule A, B, and C property or assets, and its representation of the partnership in any manner in the interest. One of the reasons given by the
on
learned judge.
8/1/2023.
Pardon?
This is on 8/1/2023.
Yes, ma'am.
As on the date, what is the status?
Today.
As on that date, on 8/1/2023.
As on that
In the
day,
suit- In the suit, what is the interim order?
there was an injunction up, there was an ex parte injunction was operating against me in the suit filed by the trust,
Hmm.
claiming to be the lessee in respect of 56,000 square feet.
Hmm.
That is not in dispute. Injunction still operating, we have filed an appeal. Nobody wants to dispossess Srinivasa Trust as on today. Or that we are saying is the firm. It's only the firm.
These two respondents in section 9 application, they are the trustees.
They are the trustees and also the partners.
Understood.
The
So,
trustees and also the
the
partners.
trustees, they had the benefit of interim order.
They have the interim order not to dispossess. Not to dispossess. Nobody wants to dispossess them. All that I'm saying is, let them not encumber the property.
Lord, I just want to, instead of wasting the time. He wants, my lord, an interim order not to alienate that 39 guntas of
Yes,
land
yes,
belonging to the
yes,
firm.
yes.
Your lordship may, my lord, record my undertaking. I think that should satisfy my
Yes,
learned
yes,
friend.
yes.
Instead of wasting your lordship's time. That's why-
Also, let them,
My learned friend thought he was saying
let,
something else.
Mr. Holla is magnanimous always.
No,
But
this
the problem
statement-
is,
this
I
statement
did
should
not
have
know
come at
that
the
he.
beginning.
ಇಲ್ಲ ಅದನ್ನ ಹೇಳಿಲ್ಲ ನೀವು ಆತರ ಹೇಳಿದ್ರೆ ನಾನು ಮುಗಿಸೇ ಬಿಡ್ತಿದ್ದೆ.
No, we heard a matter where there is no dispute.
And one more thing is, let them show how much money they are making in that. We have a right to know. We are right to know, to see the books of account. We are right to know the books of account. We are the joint owner. We are not given a single rupee. My
Those
brother
things-
is
no,
dead.
No, those things, once the arbitrator is appointed, you can move section 17 application and seek appropriate orders.
Only one, no doubt about it. Unfortunately, what happened, my lord, my brother who went to Sri Lanka, there was a bomb blast and he died. These legal representatives, they do not have a penny to live. He is making, my lord, exorbitant amount of money from the educational institution. Let him, my lord, after all, who is he paying? The sister. Sister should pay to brother's children. That's all I'm asking. Not my brother-in-law. After all, the sister has to.
Have you moved section 11 application now?
Yes, yes.
After
Now,
it's-
what is happened?
Pending. Are you disputing the arbitration clause?
No, it is there in the partnership.
If you, both of you can give consent, we can appoint an arbitrator suggested by you. Arbitration proceeding can commence.
No. Yes, just Jagannath.
No, both of you suggest a name.
Justice
So
Jagannath.
interimly, if you want, you can move on to section 17.
ಅವರು ಜಗನ್ನಾಥ್ ಅವರು ತುಂಬಾ busy ಇದ್ದಾರೆ.
Any,
Somebody-
ಅಲ್ಲಿ ಒಂದು ಲಿಸ್ಟ್ ಇರ್ತದೆ ಮೇಡಮ್ ಹತ್ರ.
ನೋಡಿ, both of you agree upon an
Yes,
arbitration.
settlement. Or Justice Ashok bin Chigeri, whatever.
ನಾಗಮೋಹನ್ ದಾಸ್ ಅವರು.
Justice Nagmohan Das. Yes.
Third, learned senior counsel Sri S. Basavaraj appearing for the appellant and Sri Uday Valla, learned senior counsel appearing for the
ಅವ್ರು ಕೊಡ್ತಾರೆ.
respondent. This appeal is filed against the
ಅವ್ರು ಕೊಡ್ತಾರೆ.
order under section 9 of the Arbitration and Conciliation Act 1996. In terms of the said order, the court has rejected the application to section 9.
So what?
Learned senior counsel Sri Basavaraj appearing on behalf of the appellant would contend that is before this court on a limited prayer that the respondent should not encumber the property in dispute. That is the property measuring 39 guntas and survey number.
Survey number.
193/4.
20/1.
193/4, Nelamangala village, Kasba Hubli, Nelamangala. Trade.
Pension not put. Survey number.
One ninety-three bar four, but page number 36.
All right.
Page number 36, my lord, the schedule is given.
They will have learned senior counsel appearing on behalf of the.
193/4.
Would submit that the property will not be encumbered.
193/4, Nelamangala village, Kasaba Hubli, Nelamangala Taluk, Bangalore Rural District, measuring 39.
It will not be encumbered till the disposal of the proceeding before the arbitral tribunal. Full stop. Learned senior counsel.
We may permit it to inspect the bank accounts as a partner.
Learned senior counsel, Sri Basavaraj would also submit that the appellants have invoked section 11 of the Arbitration and Conciliation Act 1996.
Well, we'll only inspect, we'll not
To appoint an
interfere.
arbitrator. Sri Udayawala would submit that the court may appoint an arbitrator to resolve the dispute as the respondent is not disputing the arbitration clause. Full stop. Learned senior counsel for both the parties on instruction from the parties would jointly submit that Sri Justice Nagmohan Das, the former judge of this court, be appointed as an arbitrator to resolve the dispute between the parties. Full stop. Submission is placed on record. Should we need consent? You have to take his consent, right?
I don't think, because he is not one of those busy arbitrators.
No, we will say subject to his availability. We will say subject to his availability.
Yes.
Subject is
Subject, subject, yeah, definitely, I understand. I understand.
Subject to the concurrence and availability of Sri Justice Nagmohan Das, former judge of this court. Sri Nagmohan Das is, Justice Nagmohan Das is appointed as an arbitrator to resolve the dispute. The parties are at liberty to approach Sri Justice Nagmohan Das. Further proceedings to be taken up on this regard. Till the disposal of the proceedings before the arbitration tribunal, the respondent shall not encumber the property in dispute referred to above.
Property is dispute ನಮ್ಮ private property ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. 194
Property which is subject matter of section 9 alva.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಎಲ್ಲವೂ ಸೇರಿಸಿದ್ವಿ.
Property referred to above.
Great.
Blood, we will, on a particular day suggested by them, we'll visit and see the books of account. It's our firm for
Those
heaven's
things,
sake.
you can invoke section 17 before the arbitration. Before the arbitration. So who will appear for R2? R2?
I appear. Both are.
Krishna, Stone, C. Krishna. Please.
So CMP is disposed of. CMP is disposed of.
Lord, I always say, the lawyers assist, disposals can be very fast.
18, Kumar Emman.
For a Loudon partner, section 37. Yes.
19,
For the petition, it's regarding a transfer of police sub-inspector, my lord. Writ was allowed on the ground that, my lord, I am disturbed him, but that is not so, my lord. Nobody has brought to the notice of this court the earlier transfer order. In the memo I filed, my lord, this 9/1/2024 order was modified on 13/1 on the ground that, my lord, 9/1 order is passed by mistake. Then this court has taken the view that, my lord, when the police station passed the order, they can't modify it. Modified with the reason, my lord, therefore, my lord, tribunal has dismissed the application on the ground that, my lord, with the reason it was modified.
Just,
Please, Lakshmi,
you working, you are the,
yeah, I am the third respondent in the earlier writ petition, my lord. First day came, my lord, my colleague was there, man, he could not brought to the notice of then government advocate also, my lord. Earlier tribunal, my lord, called the record and after verification, my lord, it was found that, my lord, when genuine reason, it was modified, my lord. He was posted, my lord, as if against the vacant post, but that is not so, my lord. I have been working since November 23. I produced that order. Nobody has brought to that notice, my lord. Transfer orders.
9/1/24.
Yes, 9/1/24 order was passed as if he is posted to vacant post. That is not so. I've been working since November 23. I produced that order with the memo. Your lordship able to take charge immediately. It will affect us. 23 order is I produced, man, if the memo. Still I have been working.
What is the finding in the judgment now?
Your Lordship directed to go and take the charge.
Just a moment.
Produce the order.
Remained vacant to the due to the non-joining duty. 42. Dated 12/1. Petitions of police inspector, Malpe. Malpe on 12/1.
9-1 is the first transfer order, madam.
A1 is a transfer order.
Yes, A1 is this, 9-1 is
The
it.
date.
9-1, my lord. 13-1, my lord, it was recalled and my lord, till 13 he did not, because my lord, he has not relieved from the earlier post itself. 9-1 order is as if against the vacant post. That is wrong, my lord.
9/1 order. Where was
Yes.
the challenge against the 9/1 order? Did anybody
9-1
challenge it?
challenged by the third respondent before the KAT, my lord. KAT, my lord, dismissed the application. Here, my lord, on the ground that, my lord, 9-1 order cannot be revoked on 13-1. On that ground, it was.
Just a moment.
Please.
9/1 order was not under challenge. What was under challenge was the 13/2 order. by
Yes,
which
yes,
the
9-1 order is in his favor, my lord. 13-1 is,
But nobody challenged the 9/1 order.
no, is, my lord.
You also did not challenge the 9/1 order.
Because my lord, it was not implemented.
What is the consequence of setting aside the order dated 30/2/2024?
9/1 order
Order
will-
revives.
9/1 order revives. Therefore, 9/1 order, there was never any challenge even by you on the ground that it is
No,
no
no,
premature
no,
transfer.
no, because my lord, 13-1, by 13-1
9/1 order referred to you,
is 9-1 order, my lord,
referred to you.
is, my lord. It is a impugned order before.
Yes, please
Is-
show
is-
us.
9-1.
What is the 9/1 order?
9-1 order is, my lord, as if the third respondent post against the vacant post. In fact, that is not a vacant post. I have been, that post was not vacated.
Second post, that order should have been challenged.
No, not rectified by the police establishment board itself on 13-1. After came to know that, my lord, after came to that,
Did you produce this 2011 order at least before the tribunal?
nobody has.
Is
No,
this-
police establishment themselves, my lord, came to know that that is a wrong order, 19-1. Therefore, my lord, it is recalled. Therefore, there is no question of challenging 9-1.
Stated in the 13/2 order that it was because there was no vacancy there that it is being recalled? No.
The police station, no, police station board was recorded in the proceedings, 13-1. There was a record by the police station's board. Record was called by the tribunal and tribunal found that matter that there is a reason to recall.
You did not raise such a
Yeah,
contention. You
that's-
were on record before the tribunal. It is not your colleague's fault for not placing it
Yes.
here.
Yes.
It was not placed before the tribunal. How will the
No,
tribunal?
tribunal called the record from the police station's board where it was recorded. Therefore, my lord, his application was dismissed. After tribunal called the record,
Without you raising such a contention.
now it is a fact that, my lord, it is not a vacant post. Then tribunal came to know that, my lord,
This has to be,
Has to be done.
has to be heard, it is true, but you have
Yes.
brought this upon yourself.
Yes.
You should have raised such a contention, at least placed it before court,
yes,
at least when we were hearing the matter. No such contention raised. How
Yes.
were we to know that you were there on 2011?
no, the matter
or
was,
some other
no,
date
first
and-
day it was posted. He thought that, man, it will give time to file a. I'll serve the copy to the advocate who appeared in the, till then, my lord, at least.
Yes,
Now,
yes.
I am working, my lord, now.
Notice in the review petition. Please accept notice. The learned guarantor accept notice and seeks time to get instructions. Issue notice to the
Yes.
private respondent.
I will serve the advocate who appeared, my lord,
Yes. or
so
court
that
also.
short date me, and I have been working, my lord, at least that portion may be stayed. Your lordship directed to take charge immediately. Nobody has relieved. I am working there, my lord, he is working. He had given posting. Short date will be given, I will serve a copy to him, my lord, till at least.
To hear.
Yes, tomorrow.
Yes,
Serve
ma'am.
a copy.
Yes, please, please.
20.
So rises in the old act. Then vote yet. First time I'm considering English looking under that. This remember the grounds for interference and in appeal under that. 1940 Arbitration Act. 1940 Arbitration Act.
The appellant is the employer and the respondent is the contractor. The contract was awarded to the respondent for relocation of the crusher plant. And the cost of the construction was, that is a civil works, 6.93 crores. The payments that are made by me is 5.88 crores. The balance, even according to them, it should be 1.05 crores. 1 crore 5 lakhs and all.
When was the contract entered into?
That was contract was entered into in 1992. That is
There
on
may-
6/3/90.
There may have been several escalations
Yes.
between then and the
No, it was terminated in 95.
95.
Terminated in 95. The arbitral proceedings itself has taken around 20 years, or the further proceedings have costed me so much. My grouse is that under the 1940 Act, the claim was around 6.95 crores before the arbitrator, which was not the agreement at all. That was not the agreement. And before the arbitrator, certain claims were made which were beyond the scope of the contract. And that was also considered, and that has been granted on the ground that 50% both are at fault, hence 50% is given to him. And 2.40 crores are given to the 2.40 is the award. That award is under the 1940 Act, which required to be made into a decree, and an application was filed by the other side before the trial court. An objection was raised by me there to the effect that to get it into a decree, they must pay stamp duty on the award. And they took 16 years to pay the stamp duty. 16 years. And in the meanwhile, that AC2, that is the case number, that was dismissed for default. And it took 6 years for them to get it restored. And for all this period, the interest is mounting on me.
What was the stamp duty payable?
Pardon me?
What was the stamp duty payable?
That was around 34 lakhs or so.
34 lakhs stamp duty.
He paid it in the end after 16 years.
Submit, Manas.
Yes, sir. And stamp duty becomes the part of the cost.
No. It doesn't come within the ambit of this litigation at all. That is a stamp duty payable to the state, not as a court fee or any such thing. Stamp duty to the state.
No, understood. That is understood. But you dragged him to arbitration proceeding. He has to.
At his request, arbitration proceedings were initiated.
Whatever.
Yes.
He succeeded.
Yes.
So he has to pay the stamp duty.
Yes.
So
that is the award.
No, that means the award says that you are the defaulter.
Defaulter as far as the amount found due. But as far as stamp duty is concerned, that is not my concern at all. If your lordship could kindly see at page 55, ink page 55. What is the observation of the learned arbitrator? Award. In the result, I make an award in favor of claimant for a sum of rupees 2.4 crores in respect of so and so, and interest at 10%. So next para. cost of the stamp duty and court fee, if any, shall be borne by the claimant. And then next, there is a note, my lord. Next page 56. I am handing over this award and all the papers with me to the claimant, who shall file the same to the court if necessary and get the award made into the decree, etc. As per Arbitration Act of 1940. The claimant also shall bear the expenses, including the stamp duty and the court fee in connection with the same.
You challenge the award? No.
Yes.
You challenged.
No, yes, I challenged it.
How?
He, under section 30 of the Old Act, for setting aside the award.
You challenged.
Yes, on the ground that was not the contract, that was beyond the contract. Whatever is granted to him is beyond the contract. Even if the contract is looked into, the payments are made by me, the balance.
When did you challenge?
Millard, under section 30, in their petition, in AC, when they filed an application for under section 14 for making for passing of a decree, I filed an application under section 30.
You filed?
Yes. Immediately, I entered appearance and filed an 1940 Act, my lord.
So he seeks decree under which provision?
Pardon me? 14, section 14, Old Act, my lord. That's the first act.
Correct.
That was the subject matter of various writ petitions, my lord, whether stamp duty is payable or not. And ultimately, he was made to pay.
Now your grievance is only confined to interest.
Lord, even I question the award also on the ground that it was beyond the scope of the contract. But grant, if your lordship would kindly see, I will just point out the claim made by them at page 39, my lord, at page 39. These are the claims which they made. The first is payment due on 17th bill, out of which the balance payable is stated as 162.802 lakhs. Then underutilized overheads, 54 lakhs. 3A, in respect of utilization of the tools, plants and machineries, 84 lakhs. Next, 3B, higher charges, 312 lakhs. 3C, depreciated cost of the machinery, 15 lakhs. Lord, only 2, 3A, 3B and 3C are granted. The rest are rejected. And total claim was 679.498 lakhs. The contract itself was 6 crores and odd. He claims another nearly 6.779 crores, apart from 6 crores and odd.
No, this court fee or stamp duty is to be paid on the award passed by the arbitrator, or is it to be paid only if the court accepts it as a decree?
No, my lord, the earlier law, 1940 Act, it was to the effect that before filing it to court for getting it converted into a decree, he should have paid the stamp duty. Later, the law is changed, my lord. Later, the law is
the provision. Which is the provision?
My lord, instead of that, the earlier proceedings, if I may be permitted to, I will just point out the writ petitions in which that such an observations are made.
Between the same parties?
Yes, what happened was, I took up a plea that it requires stamp duty. Then the learned judge, he said that no, it cannot be. It can be done at the time of executing the award. That was questioned in a writ petition before this honorable court by me. His lordships were of the view that yes, he is bound to pay. All the about 4 or 5 writ petitions have come into.
All right, when that judgment is passed, when that order is passed.
I will just. 27th May 2011. 27th May 2011.
So, education, whether it's paid or not. One court hand in his favor, he may not pay.
Stamp duty ಇದರಲ್ಲಿ ಕೊಡೋದೇ ಇದೆ.
The scope for interference under the old act.
But
Scope for interference for the award under the old
Yes,
act
yes.
is still limited compared
Yes,
to
my
the.
lord, yes,
Much limited.
yes. I will just point out even that also, my lord. In an appeal under section 39, my lord.
Properly procured or is otherwise.
The same fact almost opposed to public policy is there, my lord, in almost all the acts. 40 acts ಇದೆ.
The scope is slightly wider.
Read out 39.
Properly procured
Book
or
for-
otherwise otherwise.
Lord, what my submission is, 2.4 crores is the principal according to the award. The interest, if it is calculated for no fault of mine, it will be around another 7 crores or something. And the delay for not furnishing the stamp duty, paying the stamp duty, it has costed nearly 16 years. And 6 years of dismissal of that case and again restored,
The dismissal, no difficulty in understanding. That period has to be excluded.
6 years, 6 years. 16 years,
But That is your
60
fault.
I will submit. To my learned senior friend submit. I will bring certain facts to the notice of this.
And the aspect is, your lordship may kindly see, these, as I pointed out at page 39, these underutilized overheads, there is no such agreement in between the parties to pay all those things. But what they say is, mine is a compact unit, my place is a compact unit which is supervised by CISF, Central Industrial Security Force. And if anybody wants to come, CISF should permit. And he is a contractor. If he wants to enter, he must ask me permission. I in turn has to give it, request CISF. So when his agreement was terminated, contract was terminated, what was his duty? He must request me to permit him to take back his material, his machineries. No such request is ever made. No request is ever made. And if you were to make a request to me, I would have passed on that request to the CISF.
According to you, what is the amount payable by you?
Well,
To what extent you are admitting?
there is no amount payable because he did not complete the work. He did not complete the work. He left it. We terminated the contract because of non-completion of the work in time. Well, the fact is, the contract was entered into on 6/3/92. Completion of the contract was to be on 31/3/94. Almost 2 years, my lord. And time was extended at his instance twice. 9 months was further time was granted by me, which was in force till 31/12/94. 9 months was extended. And in spite of such extension, the contract was not completed. The work was not completed. Then the agreement was term.
For non-completion of work,
Pardon, my lord?
there was no penal clause for no consequence for such non-completion.
My lord, I have
provided-
filed a suit and I got a decree against him. That because I wanted to make a claim in this arbitral proceedings itself. He raised an objection that there is no agreement of arbitration. There was one mistake in the arbitration agreement saying that the contractor could invoke arbitration agreement was there. My name was not there. That was a mistake. So I was made to pay a lot of court fee and I recovered around 54 lakhs from them.
Yes, sir.
And it is an admitted fact that both are at fault. That is the version of his by the learned arbitrator. Both are at fault. When both are at fault, the learned arbitrator says, I will give him 50%. That is wrong, Murad. The reason being, when both are at fault, no relief could be granted to anybody. And any relief that should be granted, it should be within the ambit of the contract. It is beyond the contract is my submission. We could not produce it's almost half cartload of records are there pertaining to this. I could not carry it.
So we are also scared of securing. the
ಅದೆಲ್ಲ
records.
ಸ್ಕೇರ್ಡ್ ಅಲ್ಲ, ಅದು ಎತ್ಕೊಂಬರಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ನಮ್ ಕೈಲಿ, ಹಂಗಾಗೋಗಿದೆ ಅದು.
Please, my lord, may I submit? Please. My lord, the contract, my lord, original contract was entered on 6/3/1992 for the transfer of the crusher plant. It's in Kudremukha Iron Ore Company, my lord, the excellent here. My lord, the heavy machinery, my lord, were mobilized by the respondent number 1, my lord, for the carrying out of the work. After during at the time of tender, the appellant, my lord, gave 6 drawings to the petitioner number 1, which were ultimately increased to 582 drawings at the end. My learned friend, my lord, has just pointed out before my lord that, my lord, even I did not complete at the time of the completion period which was prescribed. If I may draw my lord's attention to page number 50, my lords. 50, my lords. The internal page number 13 of the award passed by the learned honorable arbitrator. My lords, may kindly permit me to read first line. The agreement stipulated that the project should be completed on 31/3/1994, but the drawings were issued even thereafter. My lords, they kept on issuing the drawings to me even after the completion period. And my lords, none of the drawings, my lords, the arbitrator has pointed out that the drawings were not served to me, my lords, well in advance, and that is the reason why I couldn't complete the work. Now, my lords, the main dispute, my lords, is with regard to the machineries, because, my lords, of several reasons, the project got delayed. And the reasons for the delay, my lords, are not attributable only to the respondent number 1. The machinery cost, my lords, has increased. And for that reason, my lords, the honorable arbitrator, my lords, at paragraph number 19 at page number 52, 19 and 20, there is a concluding remarks, my lords. The next question pertains to machineries, etc. The agreement was terminated by the respondent as per Exhibit R3, dated 7/12/1995. The agreement provides for retention of the machineries by the respondent to complete balance work. That does not mean the respondent is entitled to prevent the contractor to take away the machineries at least after the completion of the works. Admittedly, the complainant has several machineries and the equipments at the site. The respondent cannot take away them without proper gate pass issued by the respondent. The details of the equipment are found at page number 174, etc. of volume A2. One of the claims of the claimant is for the cost of the machineries at its depreciated value. The respondent has not shown any evidence to show that the claimant had taken away the machinery in time. The respondent has also not denied that the claimant had hired several machineries, and its claim for the higher charges after termination of the agreement is not factually denied. The claimant averred that the claimant had to pay higher charges. In the statement of the claim, the claimant had stated that it had deployed tools, machines, plants, machineries, etc., whose collective rental value or higher charges amount to 4 lakhs per month. In the reply statement at page number 32, the respondent has not denied the factual assertion, but questioned the legality of the claim because of the delay alleged against the claimant. Therefore, I conclude that if any delay is found against the respondent, a portion of the higher charges shall also be paid by it. My lord, similarly, several other contentions have been raised by me, my lord, alleging that because of the monsoon, heavy monsoon, my lord, in Western Ghats, I could not complete the work, my lord, within the time. And my lord, even the entire village, my lord, was evacuated, my lord, because of the heavy monsoon at that point of time. And the delay was not due to me. And due to the constant, my lord, issuance of drawings and revalidation of the drawings which have already been, my lord, concluded, my lord, there was a delay, my lord. And because of this delay, my lord, the heavy machineries which have mobilized there, I started incurring heavy costs. And that all has been considered by the arbitrator, my lord, and the award has been passed, my lord, saying that the 2.4 lakhs, 4 crores, my lord, must be paid, along with 15 lakhs, my lord, for the charges and 10% interest. My lord, my learned senior friend, my lord, also raised the contention before this honorable court, my lord, that I have not paid the stamp duty on the award, my lord, which led to a delay. My lord, my respectful submission before this honorable court, my lord. My lord, may kindly see, my lord, my claim petition. The claim, my lords, is only with regard to the damages which I have sought before the arbitrator. As the writ court, my lords, of this honorable court, my lords, has already passed an order. My lords, if it pleases, my lords, may I submit, my lords, these two orders, my lords, of this court. Has said, my lords, that when only damages are sought, it cannot be impounded, my lords, under section 11 of the Karnataka stamps. Now, my lords, if I may permit it to read para 8 and 9.
Yes.
8 and 9, my lords. The contention of the learned counsel for the petitioner that the impugned award deals with money which should be construed as movable property is unacceptable as Article 11 of the Karnataka Stamp Act 1957 dealt with only tangible property and not something which is not tangible. In that view of the matter, the question of impounding document under section 33 of the Karnataka Stamp Act 1957 does not arise. The executing court has rightly rejected the application filed by the petitioner. There is no error in the reasoning of the executing court. In
No,
this
what he
matter,
says is, you have already suffered an order
Please.
relating to payment of stamp duty.
I have not suffered the order.
That's what he said.
I will submit. I will clarify that. What has happened? When I filed the application for the decree, the counsel for the other side filed an application for impounding. Then I raised the contention that I am not liable to pay the stamp duty, and the stamp duty must be collected at the time of executing the award, and not at the time when I filed the application. Now, that was contested by the other side before this honorable court. And this honorable court initially said, yes, you have to pay the stamp duty, and accordingly, it was valued and I have paid the stamp duty, and I again went back to the court. There again, one more application was filed by the appellant saying that it must be impounded and 10 times penalty should be levied on the other side. Now, again I came before this honorable court and challenged it. Around 3 to 4 writ petitions were filed. During the pendency of one of the writ petition, which is mentioned also by my learned friend in the second page, which is writ petition number 15403. What has happened, there was a stay on payment of the stamp duty, penalty, 10 times penalty. At that point of time, the trial court erroneously passes an order saying that since I have not paid the deficit stamp duty,
Dismissed for now.
dismissed for now.
No,
Even
no,
though there was a
no, no,
stay.
no, no. That may not be correct.
I will submit.
Nobody appeared on the dismiss made, not on the ground of non-payment of stamp duty. Let it not be said in a.
Small question, whether the proceeding was stayed or the order paying penalty was stayed.
Penalties. Because I have
Proceeding was
already-
not stayed.
because I have already paid the stamp duty. Only penalty was pending.
Proceeding was not stayed.
Absolutely.
Proceeding was not stayed.
You are supposed to appear before the court.
Absolutely. What has happened? The earlier counsel who was appearing before the trial court was supposed to inform the trial court that penalty is not liable to be paid. And it was recorded in the previous date that already a writ petition has been filed by the respondent number 1 before the High Court, and the same is pending. The trial court, what does it mean? That the counsel for the respondent number 1 does not appear, and the penalty on the award is not paid, therefore it is dismissed for default. That is the observation. Thereafter, I challenged it before, filed a miscellaneous petition before the trial court. Throughout the pendency of the petition, miscellaneous petition, the trial court said, that I have to pay the penalty, then only it will allow my miscellaneous petition. And ultimately, what happened is, I came before this honorable court, I moved it before this court. I said, I am ready to pay the penalty, let it be adjudicated, because it's been 30 years. I've been waiting for this. Then, it is not an order from this honorable court. In fact, I said to this honorable court that I will pay whatever the penalty it imposes, let it be adjudicated. Then, it was taken on record. I was directed to pay, I ended up paying 35 lakhs, as the penalty, even though under the law I was not required to pay. Because there was a delay, 1996, I have been waiting for this amount. Then, I went before the trial court, and it was allowed, restored. Then the decree was passed. Now, my learned senior friend has not challenged it under 15 of the 1940 Act. 15 of the 1940 Act states is with regard to modification of the award. Under 30 their grounds are very limited. Only when they allege there is a misconduct on part of the arbitrator, then only it is maintainable.
Which is the provision which enables you to move the court seeking decree?
Well, under 14 only I have to seek decree.
14.
My lord,
And objection will be under 30.
Please.
Under 30, he not file one more application.
Well, under
30,
30, my lord.
30, I made another application.
All right.
Well, he has filed.
For setting aside that award.
For setting aside the award, my lord, section 30 application was filed. I filed my objections to that section 30 application. My lord, the same has considered by the court, my lord, and said that since the appellant, my lord, herein has failed to establish any of the grounds alleged in section 30, it has to be decreed.
Be done without there being stamp duty on the award.
Correct to that.
My lord, even
You filed application under section 30.
Yes.
To set aside the award.
Yes.
Can it be done before the stamp duty is paid on the award?
My lord, the question of stamp duty was partially
No, no. For academic
disposed
reasons,
of.
we are asking. What you are saying is.
Yes.
Even to seek a decree, he must pay the stamp duty.
No, my lord,
And to set aside
when
the
he had made a petition under section 14, and a petition under section 14,
Taking award,
I immediately filed a petition, application under section 30.
The question is, your contention was before the trial court. Under section 14.
Yes.
That unless he
Stamp
pays the
duty is paid.
stamp duty, he cannot seek decree.
Decree, yes.
So whether the same analogy applies to you also, unless
Yeah,
you.
if
unless
he
the stamp
cannot
is-
seek for a decree without payment of stamp duty, then my application will not survive.
No, whether the same analogy applies to you also, to say that award is to be set aside. should
No,
not-
no stamp duty as far as I am concerned. No stamp duty is, I am questioning the award, no stamp duty is payable. Nowhere, the responsibility of paying stamp duty is
That is
in,
understood. That is understood.
as far as I am concerned, there is no law that I should pay the stamp duty. My lord, the law has changed after 1940. It is only at the time of execution. There is a direct decision on that point also.
was given in the award, my lord, it is not mentioned when it has to be paid.
Setting aside.
It is the award that is being.
I just wanted to know.
I understand.
It becomes an award only on payment of.
No, that does not appear to be. the case.
If I may be permitted to read one paragraph of his lordship Justice Mohan Shantan Gowda.
The making and selling. Even the amount
ಇದು ಇದರಲ್ಲಿ
of-
ಇದ್ರ ಬರಲ್ಲ.
What is what is what? It's a remaining thing. It is for the purpose of execution that it is to be submitted and then together with it. For challenge. It does not.
Make
appear-
it a decree.
Hmm.
And we sign stamp.
It does not appear to. Then it is not possible to what a remaining. For challenge. If I need for making an application to satisfy the law. The court should have to determine for making an application to satisfy the law. What such application having been made after refusal. Proceed to following judgment having to be over. And upon judgments of the completion. If it doesn't. It could be.
No amount is deposited so far.
Pardon, my lord?
So far, no amount is deposited.
The award has now become operative. It's now become operative. Lord, ours is a government of India company. Unlike a private party, I can't go and pay the amount to them directly because all the formalities are to be followed. And if at all that award is not converted into a decree, they could not have executed it. They could not have executed it. And it is only now the liability is upon me.
Requires consideration. Some interesting points are there.
As far as
But it
court
can't-
fee is concerned, I mean, stamp duty is concerned, it has ended up.
But it can't be unconditional stay.
Which one, Milord?
It can't be unconditional stay.
Milord, I don't even say that, Milord. I know my limitations because from 92, they are there, I am there, and both are there in the fray.
No, still, what is the period in which, when it was dismissed for non-prosecution, when it was restored?
Milord, I'll give the dates. I'll give the dates. 22/7/2017 was the date of dismissal.
Hmm.
Then it was restored on 11/4/23. 11/4/23,
What is the rate of interest awarded?
10%. Throughout, there is no splitting or any such thing.
Malas in para. Page number
That dismissal.
21, my lord.
21.
The learned judge, my lord, has
21.
already noted, admittedly, the project has been completed. Plus, after going through all the records are voluminous, my lord, they couldn't be brought before, my lord. If I may read, my lord, internal page number 9. Further, it is an admitted fact that the work order agreement dated 6/3/1992 was issued and the said work order agreement was supposed to expire in the month of May 1994. Further, it is an admitted fact that the work entrusted to the plaintiff was completed. Malas, already the
That
machinery,
is
my
by the
lord,
learned
has been,
district
my
judge,
lord,
my lord.
commissioned. Has been commissioned. So I have already completed the work, my lord.
This
And
may not
whatever
be-
the-
No, just a second. Your contention is that award is beyond the scope of the agreement, right?
Yes, my lord.
So all that you need to produce is the agreement.
Yes,
That's all. Other
yes.
records are not required. There
Yes.
is no need to
Yes,
appreciate the
yes.
evidence.
my
My lord,
if I
as
may
far as the
submit-
agreement is concerned, it is tagged on with the general conditions
Now
of
we'll see.
contract.
Now we'll see
That will
whether
be
it is
there. Yes,
beyond the scope or what. That's all.
Yes.
That's the only concern.
yes, my lord. What all has been granted is only beyond the scope of the contract. That is my contention.
May I speak, my lord, that 100% may be deposited.
100%,
1996 have been-
100% excluding this period. Excluding this period of
Excluding the interest for the period when it was
Dismissed.
dismissed for non-prosecution.
And that dismissal was not for anything, for his non-appearance,
Address my
not for
argument on that
non-payment
point.
of this one.
No,
Please,
yeah,
I-
we'll consider it.
That we'll
please,
consider.
please, very grateful.
Third learned counsel appearing for the appellant as well as the learned counsel appearing for the respondent. This appeal is arising from the decree passed in AC number 2/2007
Plus interest.
on the file of City Civil Court, Bangalore. Full stop, wherein the respondent's application with a prayer with a prayer to pass a decree in terms of the award passed by the arbitrator under the Arbitration Act 1940 is accepted. Full stop. The respondent before the trial court is before this court. Full stop. Learned counsel for the appellant would submit that the award passed by the learned arbitrator is beyond the scope of the agreement between the parties, and arbitrator exceeded his jurisdiction in passing the award, and said award holds play of section 30 of the Arbitration Act, and would contend that award is otherwise invalid. It is also his contention that from 22/7/2017 to 11/4/2023, the petition was dismissed for non-prosecution, and the appellant cannot be penalized to pay the interest for the said period when the proceeding was not pending on account of default on the part of the respondent before this court. This court has considered the contentions raised at the bar. Given the limited scope of interference under section 30 of the Arbitration Act 1940, this court is the view that the operation of the award be stayed subject to appellant depositing entire amount awarded by the arbitrator, excluding the period from 22/7, excluding the interest for the period covering from 22/7/2017 to 11/4/2023. The amount shall be deposited before this court within 8 weeks from today. The parties are directed to produce relevant documents required for consideration of the appeal on merit.
Blood stay is prayed and execution is today.
I will.
It's stayed now. It's stayed. 8 weeks time is granted to deposit.
Please.
Who is the arbitrator?
Justice Shiv Shankar, but
Dispense.
other notice to that second respondent may be dispensed.
Dispense with.
Preliminary hearing, so number 21, Nagraj Ji.
My lords, I am for the petitioners, my lord. Kindly pass for the matter, please. My senior will attend the
Statement.
matter.
Yes, right.
We have filed on Saturday, my lord. Sir. Last Saturday.
Please.
Okay.
Give
Kind-
the copies.
Yes.
This next week.
Yes, my lords.
27.
Okay.
3. Twenty-two, reporting settlement.
22 may be referred to Lokanath, my lord, will. 22.
Who appears for respondent?
My lord, we are discussing with the respondent. They have informed me that they will engage an advocate. It may be referred to Lokanath, my lord, we will negotiate and we will, most probably we will try to settle it.
Counsel for respondent. Is he ready?
The respondent is ready. According to information given to my client, they will engage an advocate and it may be referred to Adalat, they will settle it.
Lok Adalat or mediation?
Lokanath.
When it is scheduled?
Maybe in the month of next month or second Saturday, which will be. Information I am not having, when will be the Lokanath. Reconciliation meeting will also going on. We will settle it. 99% I hope that it will be settled. So my submission may be considered and I will try my all level best to settle.
Alternate counsel for the appellant would submit that the matter is likely to be settled to local, settled in, likely to be settled and request the matter be referred to Lok Adalat.
Lokanath.
Submission is placed on record. The matter is referred to Lok Adalat.
Meanwhile, I will try to get the respondent appear before. Please.
Passed on matter. Still number 1.
This is a matter pertaining to the departmental inquiry. My lord, I may be permitted to submit some brief facts of the case, which leading to the alleged departmental inquiry. My lord, the petitioner was appointed as PDO on 8/10/2010. Some dates and events are very important. Lord, she appointed on 8/10/2010.
Will we pass it over and hear it?
It could be taken up on day after tomorrow. Pass over, I am having some inconvenience afternoon. I have some other matter. Day after 26th for admission.
26th, we have matters
Please,
posted in the chamber.
26th,
27th.
28th, 27th, please.
Still number 10. Ravindranath.
Yes.
Order of the tribunal. But I need not repeat the argument already addressed.
Page 84, paragraph 59, I was pointing out the order of the tribunal. Not the DPC decision is not approved by the minister. Concerned minister gives two reasons. One is the petitioner is senior to the respondent one. Second is the DPC is concerned, it is not the alone criteria for the purpose of considering the case of promotion, the post of additional control. The tribunal did not appreciate the reasons assigned by the minister and cautions the order of promotion of this petition.
Can we first see the rules regarding consideration by the DPC and how it is to be accepted?
DPC is concerned, it is not backed up by any statute.
Sorry?
Department Promotion Committee is not backed by any statute. There is no statute which constitutes the DPC. It is by an executive order. What rule says is, my lord, it is a promotion by selection. Promotion by selection.
There is no provision in the rules
No, my
with
lord.
regard to DPC?
No. It is not. Kindly see that.
Yes.
Rules are called out. Page 113, my lord.
Yes.
Rules are called out. Notwithstanding anything contained in sub-rule 2(3) of the
Which page are you reading?
113. The DPC proceedings is called out. What is the method of regulating the promotion to the post of additional controller? My lord, got it? 113. It is in English. Notwithstanding method of recruitment. Page 113. Notwithstanding anything contained in sub-rule 2 of the 3 of the Karnataka Civil Service General Recruitment Rules 1977, by promotion by selection from the cadre of Deputy Drug Controller and Chief Scientific Officer, Drug Testing Laboratory. Minimum qualification must have put in a service not less than 5 years in the cadre specified sub-column 6, provided if officers who are not put in a service of not less than 5 years are not available, an officer who has put not less than 3 years service may be considered for promotion. Must have qualification specified under the 50A of the drug and cosmetic rules. These are the criteria. It is a, my lord, selection, promotion by selection. Seniority is one of the criteria.
Promotion by selection means merit comes senior.
Merit comes here.
Civil Services General Recruitment Rules 19.
Rule 3 of the General Recruitment Rules, my lord, mandates that, my lord, 2 plus X plus 4 is a criteria to call for the, my lord, consider the case of promotion of in that ratio 2 into the post whatever is there plus 4. Rule 3, 1 of the General Recruitment Rules. Proviso, my lord will find.
Methods of recruitment and qualification shall be as specified in the rules of recruitment, specifically made in that way, provided. With respect to direct recruitment to any service or post. Specified in the rules, method of recruitment shall be selection after an interview by the commission, the advisory or selection committee or appointing authority as
Yes.
the case may be.
Provided for the purpose of promotion by selection, the number of persons to be considered shall be such number of persons eligible for promotion in the grade of seniority is equal to 2 into X post number of post plus 2. So 2 into 1 in 1 plus 2. 6 persons is required to be considered for one vacancy. This is amended, my lord, on proviso is added on, my lord, 84.
That is the number of persons to be considered.
Yes, bro. Number of persons is under no dispute, my lord.
Anyway, this is notwithstanding anything. This selection is notwithstanding anything contained in sub rule 2 of rule 3 of sub rule 2 of rule 3.
But
Shall be by promotion from selection.
yes, yes.
Hmm.
Lord,
That is not.
general recruitment rule says, my lord, head of the department, additional head of the department are only, Lord, selection, promotion by selection. General recruitment rule says mandatory.
Correct.
But notwithstanding that, my lord, this is by, not selection by, promotion by selection, promotion by selection.
Promotion to all
But-
other posts shall be on the basis of seniority cum merit. Therefore.
The rest of the posts are seniority committee.
No, normally it is seniority cum merit.
Normally
but
it's seniority committee.
Selection can be specifically provided by the recruitment. rule.
Yes, yes.
Now, in this case, it is so.
Yes, my lord. Between the general
We
recruit,
wanted to know
yes.
what is the provision for, how is the DPC constituted? Because
Well,
normally the rules will provide.
There are no
how
rules.
the DPC.
There are no rules. That is what my argument before the tribunal. Lord, it is also, Lord, correct, it is constituted by an executive order,
Whatever.
by an executive order.
What is the?
It is
executive
not
order?
backed by any statute.
What is the executive order?
Executive order is not produced, my lord, not produced.
Anyway, that is
It
not.
is not,
in
it is,
dispute.
it is not,
Not in dispute.
it is not a dispute, not, I don't think my learned friend also
Yes.
disputes it.
Full set of poems issued
Yes.
Yes.
constituting the department. Regulating the entire
Yes,
procedure.
yes.
So it's how the procedure is. What is the DPC?
Then ತಗೊಳ್ಳಿ.
How the PCRs are to be maintained, how the DPC should be, how it. Nothing is in the.
No matter looking to promotion, ideally it should be.
Selection, both promotions, seniority, normal promotion, seniority. All that is provided for in the. 28 years, minimum it should be.
ಅದೇ, ಟಿಫಿನ್
Selections. Including the DPD. The DPD will be confusing. And we have a DPD. Only. First. Proceeding.
But I am making my submission, Lord, it is not backed by any statute.
Fine.
Constitution of the, my lord,
Executive orders where there are no statutes, executive orders can govern.
it is not even an executive order.
No difficult.
It's only a not official memorandum.
There is a,
Criteria for selection is also regulated by statute.
Executive, by statute.
May one provision, my learned friend has read rule 3.
yes, yes.
Kindly permit me to read rule 4 to 8.
Rule 3.
4
To a-
to 8. It is not an issue that it is a selection.
No, I only
No, no,
wanted to know because.
I'm not disputing that.
Yes,
I'm not disputing that.
yes. Yes, yes.
In the case of recruitment by promotion, if it is to a post to be filled by promotion by selection of a person on the basis of kindly mark, this is very important.
Yes,
Merit and suitability,
yes,
first item,
Yes.
merit and suitability. In all respect, discharge the duties of the post with due regard to seniority, kindly mark it. That is the second criteria. Merit and suitability is the first one.
in all respects. Yes.
Seniority is the second aspect.
Yes,
From amongst persons eligible for promotion. It is not in dispute, we both are eligible.
yes,
It is not in dispute, we are in the zone of consideration.
yes,
Now kindly come to the OMs I have just now placed.
yes,
Now, this job of ascertaining the merit and suitability, the government has thought it fit to have a departmental promotion committee
yes,
to assess the merit and suitability of the candidates who are eligible within the zone of consideration.
yes,
Now that the first order came to be issued by OM dated 9th October 1985. That is the first in the series.
yes, yes,
Now may I read the preamble. That's orders were issued from time to time, constituting the departmental committee to assess the suitability and merit of candidates for the purpose of promotion within the.
I'm not
spirit service.
disputing.
It.
Certain
it-
guidelines were also issued.
There does not appear to be any dispute. Now, the DPC has been constituted in accordance with this is also not in dispute. I only wanted to know whether that it forms a part of the rules or not.
One very important factor to be noticed here is
Hmm.
kindly come to the procedure
Hmm.
of Departmental Promotion Committee
Hmm.
at page 3
Hmm.
of that OM.
Yes,
The Departmental Promotion Committee should consider the confidential reports of officials for a period of 5 years immediately preceding the date of consideration of his suitability for promotion.
yes,
I will not trouble the court with the other.
yes,
So what is relevant is immediate 5 years.
yes.
That
not
is
the
what,
end.
that is what my dispute is, my lord. I will
Yes.
show on your, lord, on the basis, my lord. He has never worked in the deputy controller nearly 1 year, 2 months. It is very
Yes.
clear, my lord. Even applying this circular, can DPC can consider this case? Is a question.
Hmm.
Kindly see, my lord, the seniority list produced before the court, which would indicate that he never worked nearly, my lord, page 103. He was reverted from the post of deputy controller on 17/4/2018 till 28/6/2019. My lord, got it? 103, my lord.
Yes,
And 108, it is one zero 10. 11 is the English translation.
yes,
Umesh is concerned. It is BK Pavitra's case, my lord.
Yes.
will be, not English is not properly worded and I'm not happy to read this. Lord, he is reverted from the post of Lord, Deputy Controller from 17/4/2018, and he was again promoted on 28/6/2009. Nearly 1 year, Lord, 2 months, he never worked. How DPG can consider he is in the cadre of Deputy Controller? 5 years is the criteria. Pendisi, Lord.
Just
Just a moment, just a moment.
These facts are not.
Just a moment.
Where is the Kannada version of page 1?
Kannada version is not. Pendisi that also not. 103. PK ಪವಿತ್ರ ಪ್ರಕರಣ 1 ದಿನಾಂಕ 17/4/2018 ಹಿಂಬರ್ತಿ ಹೊಂದಿರುತ್ತಾರೆ.
Demoted. Later, in terms of BK Pavitra 2, in terms of order dated 28/6/2019, with effect from 17/4/2018, again promoted, with effect from 17. But again, it says with effect from. Suppress. This demotion is also from 17 to 17. Yes, so. Yes, yes.
Yes.
Nearly 1 year, 4 months.
Promoted with effect from the same date.
Maybe, but question you cannot consider if he worked in the deputy, that is settled law. I have the decision on this point, Lord, when IAS was considered, Lord, where I appeared. Lord, from police department, Lord, he was shifted to Lord, revenue department. Criteria was 8-year service in KAS.
That is not the issue.
What?
That is not the issue. Issue was he actually reverted? Or
He was actually reverted and
That we-
promoted.
we
Promoted. That is not, that is there in the senior text. Yes.
Will we continue after lunch?
Yes, yes.
Number 24. Responding number 3, I'll have to file my objections. Paper short accommodation.
Have you informed the?
Yes.
I'm appearing for petitioner.
Yes.
ಮೊನ್ನೆನ ಅವತ್ತೂನು ಒಂದೇ ಹೇಳಿದ್ರು ಸರ್, ಮೊನ್ನೆ ಒಂದೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಎಸ್ ಅದನ್ನೇ ಇವತ್ತು ಕಂಟಿನ್ಯೂ. ಅಲ್ಲೇ ಇದಕ್ಕೆ ಅವತ್ತೂ ಸೇಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದನ್ನೇ ಹೇಳ್ತಾರೆ.
Continue. ಕಳ್ಸಬೇಕು ರಿಪೀಟ್ ಮಾಡೋದು ನೋಡಿ ಸರ್, ಅದೇನು ಅರ್ಜೆನ್ಸಿ ರಿಪೀಟ್ ಮಾಡ್ಬೇಡ, ರಿಪೀಟ್ ಮಾಡ್ಬಿಡ್ತೀವಿ ಸೈಡ್ ಮೇಲೆ ಇಟ್ಬಿಡಿ ಸರ್, ರಿಪೀಟ್ ಮಾಡ್ಬಿಡ್ಮ. ಸರಿ ಆಯ್ತು, ಕೊಟ್ಬಿಡಂಬಿ.
Fine. What is it? No, there is no order on it.
ಮೇಡಮ್ ನ್ಯೂಸ್ ಇಲ್ಲ ತೆಗಿಬೇಡ, ಹಿಂಗೆ ಇಲ್ಲ, ಹಂಗೆ ಕಂಟಿನ್ಯೂ.
ನಂದು ಏನ್ ಬರ್ಕೊಂಡಿರ್ತೀನೋ ನೋಡ್ಬಿಟ್ಟು ನೀನ್ ಬರ್ದ್ಬಿಟ್ಟು ಮಾಡ್ದಂಗೆ ಇರುತ್ತೆ. ಏನ್ ಬೇಕೋ ಆ ವರ್ಡ್ ಮಾತ್ರ ನೀನು ಬಿಟ್ಬಿಟ್ಟಿರ್ತೀಯ. ನಾವು ಮತ್ತೆ ಹೌದಂತೆ ಆ ಕಡೆ ಇಟ್ಬಿಡ್ಬೇಕು.
and 3 months, 4 months, 4 months. From 17/4/89 to July 2019. Can his CR can be considered even though he is promoted with retrospective date afterwards? Then Pavitra, law of Pavitra 2 is declared. He never worked. His CR cannot be maintained in that cadre at all. But the person who is a member of the DPC, Lord, the third respondent has reported the CR. And 22/23, he never worked for 7 months in the cadre of deputy controller because no posting.
Yes.
But a circular does not empower the committee to give marks. Circular which is read over to your lordship, Lord, is very clear. 5 years CR in that cadre shall be looked into. Circular. And this is not circular produced by my learned friend. Clause 5, procedure of departmental promotional committee. Departmental promotional committee should consider the confidential reports of the officials for a period of 5 years immediately preceding the date of consideration of its suitability for promotion. In fact, officials who have not put 5 years service in the cadre from which they are considered promotion to the next higher cadre. The confidential reports for the period service rendered in the lower cadre to take up for 5 years service should be taken into account. However, the officials are appointed directly in the cadre which are to be promoted to higher cadre. Their total service is less than 5 years. Confidential reports for the entire period of service for former cadre should be considered for determining the suitability for further promotion. Non-availability of any confidential report of period during the 5 years should not be held against the official concern. This is how the DPC should evaluate. But the question is, the circular will not enable the DPC to give marks. And you see how DPC assessed. DPC says assessed by giving marks.
Which is the assessment?
Kindness, that was. It is there, my lord. It is there, my lord. Corrected copy, translated copy is there, my lord. A3, last occasion, my lord.
Yes.
English translation.
Yes.
My lord will find 3 names are picked up by the DPC.
Yes.
Translated copy is not correctly done, my lord. The artificial intelligence is used. All the transactions are incorrect. I am unable to subscribe such translation at all. Therefore, I told him at least translate this document, which is a vital document to show to the court. Correct. That has been translated.
Friend agreed not to rely upon.
Because
They were undertaking that I will not rely.
Because I did not rely upon at that stage because it was postponed to afternoon. Then I told my friend, I can't rely upon unless you properly translate it. Then Lord, translation was done, Lord. Afternoon it was.
Has been made available to all countries.
Yes, yes, yes. On technicality.
Yes.
On merit, I have no case, no case.
Yes.
Translation only with intelligence, not artificial intelligence.
Hope so. Hope
Human
so, brother.
intelligence, much better.
Some
Yes.
meaning can be given, but not accurate. Kindly see, Lord, how the DPC has allotted the marks. Outstanding, 4 marks. Lord got it?
Yes.
Excellent, 3 marks. Good, 2 marks. Average, 1 marks. Annual performance report. Not this DPC is not able to give marks. They can only give grade. If it is excellent, it is good, average, outstanding. he has been given 17 marks, I have been given 10 marks. DPC recommends his is the name of the respondent 1. Because he secured 17 marks. 17 marks. My lord will find BP Arun 9 marks. Dr. Umesh for the outstanding for 5 years, 17 marks. And the petitioner Nazir Ahmad 10 marks.
Yes.
But Nazir Ahmad is senior in the cadre of drug inspector, admittedly.
Yes.
He is promoted under ST quota. Lord, Dr. Umesh. Now, question number one is whether the minister or the decision-taking authority has power to differ with the view expressed by the
Who actually is the appointing authority of the government?
government. The minister has taken a decision on 2 grounds. My lord, it is also translated copy.
Rules of business permit the minister also.
Yes,
to
my lord,
take the
in
decision.
charge.
Yes.
Rules of business, my lord, 1977.
Yes,
Business transaction rules.
yes,
It is minister in charge is the person who concerned who takes the decision in the file. It will be communicated by order in the name of the governor
yes.
as an executive order, instrumentally.
Can be the principal, the secretary in charge of the department or the minister for.
But there are four officers can sign. That is not a desk officer, under secretary, deputy secretary, additional secretary, and secretary. These are the 4 authorities. After minister signs the file, they can issue order by order in the name of the government.
Yes.
Under the
Article 1.
business transaction. That order was questioned before the tribunal, appointing me as a additional controller. The minister concerned assigns 2 reasons. It is there, not translated copy, 1 page. Relevant is given last occasion.
Yes,
Page number 128, and is it not? 128.
yes,
2 reasons are assigned by him. One is A, the recommendation of DPC is not the sole criteria, number 1. Second is the petitioner is senior to the respondent 1, and he has more years service than the petitioner. Therefore, even after his retirement also he can be appointed as additional controller. That is the reason assigned by day. What tribunal finds is, yes, tribunal agrees with the decision of the Supreme Court. Yes, the concerned authority certainly can differ with the decision of the DPC. I have cited 3 decisions on that point. The my lord will find the discussion of directly come to the order, page 77, para 47.
yes,
We have, in our discussion, extensively discussed the judgment of Damania. Judgment in Katyayani and Hadapad are all on the lines of Damania. We have acknowledged the transparency involved in the Honorable Minister according reasons for differing from DPC recommendation. But in our view, mere recording of any reason is insufficient to overcome the arbitrariness, where reasons must be cogent, must be based on the same yardstick that is to be followed in consideration of DPC. We have held Honorable Minister adopted extraneous irrelevant criteria for not selecting the applicant in the first reason noted regarding 3rd respondent having more years of government service than the applicant. Irrelevant basis for eliminating the applicant stating that he has further chances to adorn high offices after retirement of the third respondent. Hence, adoption of untenable and irrelevant criteria calls for entry into this tribunal, decision of the appointing authority. We are of the view that appointing authority, Honorable Minister, could have not rejected DPC for the reasons stated in the noting on the file. The bench disagrees with the reason assigned by the Honorable Minister. But the principle laid down, my lord, in the Supreme Court in all those decisions, my lord, the tribunal agrees with it because the law is settled. DPC recommendation is only, my lord, is an advisory in nature. It doesn't, their appointing authority is not bound by the decision of the recommendation of the DPC. It is settled law. For a moment, my lord, even this court agrees with the reasons assigned by the tribunal. Question is whether tribunal constituted under the Administrative Procedures Act 1985 can give a directions beyond the scope of the prayer sought in the application is a question. The application is partly, notification dated 2/4/2024 as Annexure A1 appointing the third respondent to the post of additional record is set aside. Yes. If this court agrees with it, suppose reasons are not sufficient. According to reasons are sufficient, he says two reasons. The third respondent shall cease to hold the post forthwith on the passing of this order. Second respondent shall hold the charge of the post of additional drug controller under Rule 32 KCSR until the regular appointment. Can, my lord, it is in the domain of the employer whom he has to continue and he shall not continue. Tribunal can say, no, you hold, you do this, you do that. It has no power at all. But it is in the domain of the employer, whether 32 can be placed or the petitioner will be continued till the new decision is taken. Tribunal has no power to, not allowed to go beyond the prayer sought in the application. Therefore, my lord, the order of the tribunal, number one. Second, also kindly see, my lord, how tribunal directs. As regards the second prayer, the ends of justice will be served by directing the appointing authority, Honorable Minister, represented by first respondent in the proceeding, to consider DPC proceeding afresh and taken a decision in the matter within 3 months from the date of this order. Well, can he direct the minister who is not a party? He can simply say, order of promotion is quashed. Liberty to the government is reserved to take a fresh decision, either reconsider or reconstitute the DPC, whatever manner they want. Tribunal has exceeded the jurisdiction because it has no power to say that no, you so and so hold Rule 32 of the post of additional control. Where is the power? It is not a court, constitutional courts. They are all established under the Central Act. They are constituted. Whereas High Court is a court of record. Article 32 and 226, my lord has a vast power. It can even more the relief in any manner, but not the, my lord, a tribunal, which has to act within the corner of the, my lord, 4 corners of the tribunal acts and rules framed therein. It has no power to say that he ceased to hold the post. We will place the so and so as 32 charge, and minister is directed to say constitution. It is an application is under section 19. My lord will find the constitution of the tribunal under the act by the central government. Section 5 is the bench, how it is to be constituted. Establishment of the tribunal, that is section 4. Section
323A. We are at Article
23A, 23A and B, the central government has the power to establish tribunal.
And for transfer of matters pending before the High Court to such tribunal.
That is section 28 says, my lord.
What is the power which is being exercised by the High Court in matters which stand transferred? 226. Therefore, the power that is being transferred is, if not 226, is somewhat akin to 226. At least
It cannot be,
certain
otherwise,
matters.
my lord, yeah, that is why, my lord,
may not be 226.
I am
as
making my
such.
submission.
But then Chandrakumar says,
Chandrakumar says the tribunal is the court of first instance. That is what.
for what?
Huh?
For what?
For service matters. For all service matters, they cannot bypass the tribunal and approach this court. That is what the Chandrakumar lays down the principle. My lord knows in Sampath Kumar in 87, Supreme Court said no judicial review of the tribunal order before the High Court. Exactly after 10 years, 97, Supreme Court felt that doctrine of the judicial review of the tribunal order is a basic trust for the Constitution. Then Lord, March 97, Constitution bench said all orders are subject to judicial review of the High Court by division bench. Till that time, 10 years, all approached the Supreme Court only. Supreme Court felt, my lord, all cases are loaded. Therefore, it felt that it's a case where judicial review. Otherwise, judicial review of the tribunal is based. That is why Justice Ramjoy, this bench has held. All orders of the tribunal is subject to judicial review of this court. That is overruled and Sampath Kumar.
Yes.
My lord, Section 19 is the filing of application. Section 22 is the power of the tribunal, exercising power of the tribunal.
Yes.
What are the powers?
Yes.
Procedure, how it should follow. Section 22.
Yes.
No, question is, my lord, placing the Rule 32 my lord, order is in the domain of the employer. It can best say if it is illegal, it can be cautioned to say that within 3 years, the authorities shall take a fresh decision either on the same or otherwise. So tribunal direction to place so and so Rule 32, etc. If the post of additional drug controller till the decision is taken, is not totally cannot be sustained in law. It has no power at all. And also number 2, tribunal cannot say on the same decision you take a decision. Even authority can take a differ with the again, and they may say you take a direct the DPC to take a fresh look also. 2 things is possible. Tribunal says on the same DPC proceeding, you take a decision, recommendation. It tied the hands of the government. Can it be done? Consequential. It is impermissible according to. Then, my lord, tribunal in this case has failed to not give a proper hearing to the petitioner. Kindly take note, page 22 would indicate the table whether tribunal has given an opportunity of being heard to the petitioner in this case.
Yes.
10-4 is the admission, 16-4 for hearing, reply filed by the petitioner hearing immediately within 6 days, 19-4 for reply of respondent 2 and 3, and rejoinder of respondent 1, 22-4-24 for hearing and adjourn to 3-6 for the government's reply. Kindly note it. It was postponed to 3-6. On the memo filed by the respondent 1, again advanced on 24-4, 24-4-24, 25-4-24, kindly see, my lord, matter was advanced for hearing at the instance of the respondent 1 and reserved for order. But 16 documents are produced with the memo before the tribunal while advancing the matter. We filed objection to the memo, stating that there is a procedure now regulated under the Act to produce the additional document. It cannot be taken on record like that with a memo. Lord, the
Yes.
procedure under the Administrative Tribunals Act, kindly see, my lord.
Yes.
That too, my lord, after matter was reserved for orders.
Hmm.
I can understand, my lord, before matter was reserved for orders, it was produced,
Yes.
but you know, reserved for orders. 16 documents are produced. It is objected by the petitioner, stating that it must be supported by an application, otherwise documents cannot be taken on record. Kindly take section 22.
Just a moment, Counsel. Are those documents actually relied on by the tribunal?
Yes, my lord. Tribunal says so. It has been relied, argued on that document. And we are giving the finding. I can understand it. Those documents are not relied upon. Yes, sir. I fully agree with your lordship. I'll take to your lordship, lord, those are the finding also. Document.
Yes.
Lord, section 22. Kindly, for a moment, kindly, I'll draw your lordship's attention. Procedure production of documents.
Yes. Yes,
Section-
we've seen.
113B.
Yes.
Tribunal gives a finding stating that 22(3), nowhere it discusses about the 23(3)B at all. It discusses 23E, which is not referred me, which is not argued also. But application production of document.
Yes.
Tribunal refers the act at page 44, Provision section 22. Page 44 of the order.
Yes.
Entire section 22 is called out. But finding para 8 is 22(3)E. 23(3) is never argued also, nor it referred by me. My lord will find my objection specifically before the court is page 383. My specific objection is 22(3)(1)(3)B would apply. Kindly answer this question. Can you take those 16 documents on record? My specific objection is, kindly note it, page 383, Annex F in the paper book. My simple objection is only in, my lord, 3 paragraph. My specific objection is, respondent 3 submits that 22(3)B of the Administrative Tribunals Act regulates the production of document, discovery and production of new documents after the application was heard, reserved for orders, cannot be taken on record in this form. 22(3)(b) Administrative Act 80 provides that this honorable court shall have for the purpose of discharging its function under this act, same powers as vested in civil code. But tribunal discusses the provision of 22(3)(e), which has absolutely no concern at all, nor argued.
Yes.
Para 8 is the according to the tribunal, the argument addressed by by me. I am the person who appeared for the advocate now. It refers to the resident senior counsel for third respondent, that is petitioner. Section 23(e) of the 80 Act 85 bars the concession of documents submitted by the learned senior counsel, not particularly supported by provision. Though tribunal notes that at page 44, 3b, it says 22(3)(e) would apply. Therefore, it can be taken on record. Yes, since the argument is addressed. Kindly see, my lord, what they say is, what tribunal says is, para 9. What are the documents submitted by learned counsel for the applicant? They are in relation to argument adduced by learned senior counsel in this submission in the case. All records are copies of the records of the official respondent, including the copy of the representation of the applicant 22(9)-24, submitted to the first respondent. Therefore, none of the records submitted to learned senior counsel is adduced afresh or in the respect of which no arguments were made by learned counsel, since the records submitted by learned senior counsel are only according to factual arguments addressed by him. We are of the considered view that documents submitted by learned senior counsel so and so is admissible in terms of 22(1) of the 80 Act. But kindly see now 22(1) of the 80 Act. How tribunal wrongly refers the provision of law. How it understood the law. 22(1) is only natural justice. A tribunal shall not be bound by procedure 22(1). Procedure laid down by Code of Civil Procedure Code 1908, but shall be guided by the principle of natural justice and subject to the other provisions of this Act and any of the rules made by the central government. The tribunal shall have the power to regulate its own procedure, including fixing places, times of inquiry, deciding whether sit in public place or private place. 22(1) is only principle of natural justice. Subject to other provisions. Subject to other provisions 22(3)(b). 22(3)(b) particularly says it must be accompanied by application as per Civil Procedure Code. But these are the not document part of the main record of the application. I can understand not they are part of the main application. I could have really argued the case. Those 16 documents are new documents. They are not part of the main application. Even to argue that case, tribunal says, yes, we will consider your argument during the course of the order. It admitted all documents without hearing me and gave a finding.
Yes.
Notwithstanding that, but one more procedure irregularity is brought. After it was reserved for orders twice, once on 25/4/24, another on 30/5/24. This petitioner filed application to hear further and also application production of document. After serving a copy of on the other side with a memo to post the matter on 31/5/24. The tribunal did not even accept the memo. It says, we will consider your application during the course of the order. Kindly see the way tribunal has brought page 40, 440, 440. my lord, got it on left-hand side, handwritten portion, my lord.
Yes.
Advocate for respondent 3, that is petitioner, my lord, filed a memo in the open court stating that 3 IAs filed in the counter today, and he may be heard the matter on 1/6/2024. Honorable JM has made a note in the memo that 3 applications will be dealt along with the merit in the case. Kindly note it. Memo and 3 IAs are placed to file to the file for kind consideration.
What is the finding on those applications?
Right?
What is the finding on those applications?
All applications rejected without hearing us. One. Para, page 81, para 52. '52 and 53. 2 occasions.
Yes.
After the case has been reserved for orders on 35/24, the learned counsel for third respondent has presented a memo in the court on 31/5/24 stating that 3 interlocutory applications have been filed in the case, and therefore the matter may be brought back before the court on 1/6/2024 for further hearing. After hearing the learned counsel for the third respondent in the matter, it was directed the memo and interlocutory application filed separately will be considered along with the merits of the case. We have accordingly considered the memo and 3 IAs presented by learned counsel for third respondent. In the first interlocutory application, the third respondent has furnished a copy of the government notification 10/5/95. In this notification, the government has designated principal of Government Pharmacy College, Bangalore, as the chairman of the Institute of Director of Medical Education. This notification is not at all relevant to the facts of the present case. No prejudice has been caused to the third respondent by this notification. And then, my lord, relevancy or not, I can only argue before the court if it's taken up. Then, my lord, para 54.
Yes.
In the second interlocutory application, along with the copy of notification 10/5/95 referred to the above, third respondent has filed a copy of the complaint filed by applicant before the SC/ST Commission dated 2/5/24. Copy of the notice to SC/ST Commission to the third respondent dated 27/5/24. These documents are not at all relevant for adjudication of this case. Third respondent, if agreed by the complaint filed by the applicant before the SC/ST Commission and notice issued by SC/ST Commission, he is at liberty to seek redressal before the competent forum, independent of these proceedings. Hence, interlocutory application is rejected as not at all being relevant for adjudication of this case. The complaint of the applicant before the SC/ST Commission and notice issued to the said commission has not caused any prejudice to the third respondent in this case. Then, my lord, third respondent in the third interrogative, third respondent has rejected the reply of the state simply stated that state in its reply has contended that DPC has assessed the candidates in accordance with the rules, orders, circulars, procedure prescribed. We have already held that third respondent has not at all at any stage challenged the evaluation made by the DPC. Hence, challenge to reply by the state by third respondent is not at all tenable in this proceeding, since there is no challenge by your formal application by third respondent in an independent proceeding before this tribunal as original applicant. The third respondent has thus no locus standi to oppose the reply to this, represented by the first respondent, second respondent in this proceeding, who are at liberty to present their case with regard to the argument made in the main application. If the third respondent is prejudiced thereby, it is for him to challenge the DPC proceeding. My lord, suppose, my lord, on 31/5/2024, it heard the applications, rejected. My remedy at least is available before this court, before pronouncement of the order. Kindly appreciate this. Thus, I am able to state before this court, those applications are necessary and relevant, those documents are relevant. After hearing me, only court can say it is not relevant, it is relevant. It took it to the chamber and say, no, this application is this application, that is not at all relevant, therefore we reject. If it is rejected, suppose on 31/5 or 1/6/2024, my lord, I would have approached this court and requested this court to consider those applications. Without any remedy, the court Lord, pronounce the order that is on 11-6, my lord, 11-6. Lord, therefore, Lord, tribunal has violated section 22(1) of the Administrative Tribunals Act, which is guided by principles of natural justice. The order ab initio void, notwithstanding the case on merit, ab initio void, and it is liable to be set aside.
Yes,
These are the two grounds, Lord. I'm before your lordship, Lord.
yes.
That's all my submission.
Before you start, can I ask one, the state's reply was on record?
Sorry,
The state government's reply was on record before
it
the
is,
tribunal?
it is on record.
Was-
It
was
is on record.
On record before the tribunal?
It was on.
It is on record. It called for records. Also,
In fact, my learned friend did not mention that part of the application he had made. He made an application to reject the state government.
It was on record.
I read one. I read
No, no, no.
We've seen
He
that.
did not refer to that application. I don't know why.
My
Three
application
applications,
is three.
three applications. He referred to two applications. The third application was to reject the.
You read
Yes,
it
I
out.
read over to you. Yes, I read over.
That application is also
That was
rejected.
the first we heard about the state's reply.
Yes.
State's reply is on check on record, but directed to produce the records. Our records are not produced now. There's no time to produce it. Because 3 weeks it was posted. Again at once, 25, 24.
May I please? The basic facts are these.
But there is a reference to the reference in the order sheet that the government advocate makes a request to adjourn the matter on the ground that they have yet to receive.
Repeatedly, they made that request,
Remark.
but finally, when the matter was heard finally, the government had filed and the objections. It is on record. May I request the court to kindly permit me to show, straight away take the court to page 385. 385.
Dated 21/5.
Dated, I think it is 2/5.
2/5.
Yeah.
2/5, correct.
2/5. I relied on this. As a matter of fact, I relied. I'll point out why.
Yes.
Why
Yes.
I relied on. Now, the basic facts are these.
Sorry
the-
to interrupt you, Lord. Sorry to interrupt you. Sorry to interrupt my friend also. The tribunal has noted reply is filed. Tribunal also noted state has not filed reply, not produced record. Both are there. That's all.
Now, the final seniority list in the cadre of deputy drugs controllers has been published on 8/1/2020. That is placed before the court at page 98. Kannada version is page 98. The English version is at 104.
Yes.
Kindly permit me to show from this thing. In the seniority list, the petitioner is placed at serial number 37 at page 111.
Yes.
Page 37.
Yes.
Petitioner Nazir Ahmad is placed at 37. And the first respondent is placed at serial number 36.
Yes.
This seniority is not disputed. It has never been questioned. On the other hand, this has come into existence pursuant to an act passed by the Karnataka state by restoring reservation in promotions. Because the first respondent happens to be a scheduled caste candidate. And he was affected by the first judgment, Pavitra 1. Thereafter, Karnataka passed a legislation giving consequential seniority supported by necessary data. That has been upheld by Pavitra 2. And subsequently, this seniority has been settled, and according to it, it is just restoring the earlier seniority that existed in the cadre of Deputy Drugs Controller. This is as on 1/1/2020. Now this has become final, it is not under challenge. So I am senior to him. That is the first and foremost consideration.
Yes.
Then secondly, the DPC considered all the eligible candidates coming within the zone of consideration and has made a very comprehensive deliberation on this. The relevant rule is extracted at page 113. Since the translation is not okay, kindly permit me to read from the original in Kannada. At page 113, it is the rule is extracted in English. Cadre and recruitment relevant rule. Method of recruitment. Notwithstanding anything contained in sub-rule 2 of Rule 3, of the Karnataka Civil Services General Recruitment Rules 77, by promotion by selection from the cadre of drugs, Deputy Drugs Controller and Chief Scientific Officer, Drugs Testing Laboratory. Minimum qualification must have put in service of not less than 5 years in the cadre specified in column 6, provided that if officers who have put in a service of not less than 5 years are not available, an officer who has put in not less than 3 years of service may be considered. 2, must have qualifications prescribed. I have been a drugs controller from the year 2014.
Deputy Drugs.
Deputy Drugs Control. From 2014. And after Pavitra 1, my services came to be reverted. Now,
Yes.
but after the Pavitra 2 judgment, a general order came to be passed by the government. Kindly permit me to show.
Yes.
The short order, kindly permit me to read from the preamble. In the government order at serial number 1 above, that is dated 27/2/2019, instructions were issued with regard to the implementation of Karnataka extension of consequential seniority to government servants promoted on the basis of reservation. Act 2017, subject to the judgment and order of to be passed by the Honorable Supreme Court in MA number so and so. Later, pursuant to the interim order dated 1/3/2019, the Honorable Supreme Court in IA number so and so, instructions were issued in the government order dated 5/3/2019, read at 2 above, to the effect that no further action should be taken for operation and implementation of the government order dated 27/2/2019. until further directions are issued by the government in this behalf. 3. Honorable Supreme Court in its judgment dated 10/5/2019 in BK Pavitra and others versus Union of India and others, connected review petitions and writ petitions, rated 3 above, as ordered as under. Court. Okay, conclusion. Para 144. For the above reasons, we have come to the conclusion that the challenge to the constitutional validity of the Reservation Act 2018 is lacking in substance. Following the decision in BK Pavitra 1, the state government duly carried out the exercise of collating and analyzing data on the compelling factors adverted to by the Constitution bench in Nagraj. The Reservation Act 2018 has cured the deficiency. Kindly mark it. It has cured the deficiency which was noticed by PK Pavitra 1 in respect of Reservation Act 2002. The Reservation Act 2018 does not amount to a usurpation of judicial power by the state legislature. It is Nagraj and Journal compliant. The Reservation Act 2018 is a valid exercise of the enabling power conferred by Article 16(4) capital A of the Constitution. We therefore find no merit in the batch of writ petitions, as the constitutional validity of the Reservation Act has been upheld. They shall stand dismissed. Accordingly, the review petitions and miscellaneous applications shall also stand dismissed in view of the judgment in the present case. There shall be no order as to cause. All pending applications are disposed of. So this is the final order passed by the Honorable Supreme Court. Para 4. In view of the order of the Honorable Supreme Court, quoted above, the interim order dated 1/3/2019 of the Honorable Supreme Court merges with the final order dated 10/5/2019, read at 3 above. In the light of the above, the government order dated 5/3/2019, read at 2 above, has been re-examined. Hence, the following order. In the circumstances explained in the preamble, government order dated 5/3/2019, read at 2 above, is withdrawn with immediate effect. All the appointing authorities shall take action in accordance with the instructions contained in government order dated 27/2/2019, read at 1 above, with regard to the implementation of the Act 2013. After completing action in accordance with subpara 1 of para 8 of the government order dated 27/2/2019, read at 1 above, the process referred to in subpara 2 of para 8 thereof, including preparation and publication of the provisional seniority list, assignment of dates of eligibility, review of promotions, fixation of pay and pension as contemplated in sections 4, 5, 6, read with 9 of the State Civil Services Regulation of Promotion, Pay and Pension Act 1973 shall be completed within a maximum period of 30 days from the date of this order. Those officers, etc., other things are not relevant. So this is the order made.
Yes.
Now pursuant to this, now kindly permit me to show what is the order made after my reversion. Excuse me, page 350.
Yes.
Civil appeal number 2368 of 2011 filed in the Supreme Court and MA number so and so regarding government order number so and so dated 15/5/2019 issued by the Staff Administrative Reforms Department, Service Rules Bench regarding the implementation of the judgment passed by the court on 10/5/2019, subject to the publication of the final civil seniority list of Deputy Drugs Controller in government notification number so and so dated 17/4 has been withdrawn. Kindly mark it. So the earlier order has been withdrawn. In this background, Mr. Umesh, Assistant Drugs Controller, Chamraj Nagar Circle, who was serving as Deputy Drugs Controller and Member Secretary, Board of Examination Authority, Bangalore, Mr. Shankar Jyoti, Deputy Drugs Controller, Member Secretary, Examining Authority, Bangalore, to place vacated by his transfer, dated 17/4/2018, with retrospective effect and redesignated and appointed until further orders. So with retrospective effect, the order of reversion is withdrawn. I have been reinstated in the promoted post of Deputy Drugs Controller as if there is no break in service. And that is what is the final order. So my very respectful submission is, I have been a Deputy Drugs Controller from 2014. My eligibility has never been questioned at any point of time by anybody. My seniority list is not under challenge. And it is in these circumstances, the Departmental Promotion Committee, which is a high profile committee consisting of the Principal Secretary to Government, Health and Family Welfare. Kindly turn to page 116. In terms of the government orders I passed on earlier, this is the Departmental Promotion Committee at page 116.
Yes.
The Principal Secretary to Government, Department of Health and Family Welfare, Secretary to Government, Department of Parliamentary Welfare, Affairs and Legislation, Joint Secretary to Government, Department of Health and Family Welfare, Joint Secretary to Government, Department of Social Welfare, Drugs Controller, Drugs Department. So all the 5 members are there, and these people constituted the Departmental Promotion Committee, which met on 6/3/2024. The date is relevant for another purpose to which I'll come later. 6/3/2024, the 24, the committee met, and now kindly come to the, I'll skip all other minor details. Marks have been awarded on the basis of the annual confidential reports. That the court will get it at page 120.
Yes.
120. My case is at serial number 2. The table is not properly typed.
That we have the
It is
proper
typed properly,
copies.
but it is there in the English translation. Because of the overpage, blood, other parts have come.
So for the period 2018-19, I have been awarded only 1 mark. And since for the subsequent period, from 2019 up to 2024, for 4 years,
Yes.
I have been awarded extraordinary grading, which is quantified by way of marks by the DPC. 4 marks are awarded. So counting the marks secured for all the 5 years as required, 5 years, so this thing is concerned. Totally, this respondent has secured 17 marks. Then the petitioner herein has secured 10 marks. On the basis of the gradings he had earned in the annual confidential reports for the same period. Here itself, I should clarify one aspect. So much argument has been advanced by my learned friend on the correctness or otherwise of this thing. A pointed question was asked by this honorable tribunal, the honorable court, as to who wrote his confidential reports, whether the authority who wrote the confidential reports was the same. May I request the court to kindly permit me to show his own statement, though my learned friend made a statement that his this thing was not written by the same authority as the first respondent. Kindly permit me to show his own statement. In the reply statement he filed before the tribunal, page 156.
Yes.
At page 157, in the running paragraph, 5 lines from the top.
Yes.
The additional drugs controller, who is immediate superior officer, is the reporting authority of for the applicant. Whereas in the present case, the drugs controller, who is retiring very shortly, has played a role of reporting authority as well as the reviewing authority of the applicant, as well as this respondent, which is opposed to circular number so and so, so and so, so and so. So it is the same authority who wrote the ACRs of both the officials. It is his statement.
Yes.
Applicant as well as the respondent, both the ACRs were written by the same author. Now the fact for consideration is those ACRs are not challenged by him. He has accepted whatever grading was awarded. So it is in these circumstances, DPC has proceeded to consider. Now I have already pointed out the manner of assessing the merit and suitability is based on the performance. That performance is judged on the basis of the ACRs for the preceding 5 years. Now that is what has been done. I have secured 17, head and shoulder above him, who has secured only 10. Then the next paragraph is important. I request the court to continue.
Yes.
The committee noted the exceptional qualities and performance of Dr. Umesh, that is this respondent, in serial number 2, as reported by the drugs controller during his tenure as member secretary of the examination authority board, and the reasons for awarding him the outstanding grade. So what is this exceptional quality? Now, as a member secretary of the board of examinations, it is this respondent who has invented a mechanism of digitalizing the entire process so that there is, now court is familiar with what is happening in NEET. There is no room for any foul play. So all the pharmacy institutions in Karnataka were regulated by the innovation made by the first respondent. And if I may say so with respect, I am instructed to submit that this has now been accepted by all the pharmacy institutions all over the country as the standard procedure for conducting the examinations and announcing the results, so that there is no room for any foul play or malpractice. So that is the aspect which is taken note of. And then, based on the marks obtained according to the grades given in the performance reports of 2018-19 to 2022-23, Dr. Umesh received a total of 17 marks. Considering that there are no pending departmental inquiries or criminal cases against him, or any intention to initiate such proceedings, the Departmental Promotion Committee decided to recommend his promotion by selection to the post of Deputy Drugs, it should be additional drugs controller in the pay scale of 74, etc., etc. The meeting concluded with that. So this is the DPC recommendation. Now this recommendation has not been challenged at any point of time, not even by way of any objections to the government. And
do the circulars provide for a challenge to the government?
there is no express provision. There is no express provision. But this proposal is placed before the government for taking action.
Unless the government takes a final call on the recommendation, how can he challenge?
Sorry?
Unless the government takes a final call on the recommendation.
No, objections could have been raised. I'll come.
Government can overrule.
I vote on to that observation. I'll tell what he has done, what What other things he has done, I'll bring it to the notice of the court, be that as it may. Now, so the only proposal before the government was to promote me. There was no other proposal. Now, considering this, what is it that the Honorable Minister has done? Just to recollect, 4 factors are considered by the DPC. Number 1, ACRs. Number 2, seniority. Number 2, my contribution as a member secretary of the Board of Examination. And number 4, there are no departmental examinations, inquiries against me. I have an unblemished service record. So these are the factors, 4 factors, which weighed with the Departmental Promotion Committee. Now, what did the government do after this recommendation was placed before the government? Sir, the translation is not correct. Therefore, permit me to read the original and.
Yes, please.
So correct translation is given. Given. You given to him also. These 2 documents are very important documents. Let them copy.
Yes.
Now, before I proceed to refer to the minister's note, may I request the court to kindly permit me to show one provision in the Constitution? Because this is one provision which has been repeatedly used to strike down the provisions made in favor of scheduled castes and scheduled tribes. Article 335.
Yes.
I think this is one case where this honorable court should invoke this provision to uphold the order of the tribunal. Why I say so? Kindly come to Article 335.
Yes.
Claims of scheduled castes and scheduled tribes to services and posts. The claims of the members of the scheduled castes and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of the union or of a state. The proviso is not relevant where
Yes.
I'm not. Sir, this man is found to be of outstanding merit, head and shoulder above all other contestants.
Yes.
Is it not the duty of the minister to have in mind Article 335 while making appointments? Kindly look at what the Honorable Minister, Health Minister has done. That is available at page 128. I'll give the substance of the translation. I'll read the original on
Yes.
page 128.
Yes.
ಕನ್ನಡ. ಅಪರ ನಿಯಂತ್ರಕರ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರವು ಲಭ್ಯವಿರುವ ಉಪನಿಯಂತ್ರಕರಲ್ಲಿ ಆಯ್ಕೆಯ ಮೂಲಕ ಮುಂಬಡ್ತಿ ನೀಡಲು C&R ನಿಯಮದ ಅನ್ವಯ ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿದೆ. Post of additional drugs controller has to be filled up by promotion, by way of selection, by selection for promotion.
Yes.
ವಾರ್ಷಿಕ ನಿರ್ವಹಣಾ ವರದಿಗಳ ಆಯ್ಕೆಗಾಗಿ ಈ ಆಯ್ಕೆಗಾಗಿ ಒಂದು ಭಾಗವಾಗಿ ಪರಿಗಣಿಸಬೇಕೇ ವಿನಃ ಕೇವಲ ಕಾರ್ಯನಿರ್ವಹಣಾ ವರದಿಯೊಂದೇ ಮಾನದಂಡವಾಗಿದೆ. This is a general observation he makes. ACRs cannot be the sole basis. It is one of the considerations. That is what the Honorable Minister says. But part B, para B, is the crucial paragraph where the actual consideration. ಅಲ್ಲದೆ ಕ್ರಮ ಸಂಖ್ಯೆ 2 ಮತ್ತು 3ರಲ್ಲಿರುವ ಅಧಿಕಾರಿಗಳು ಇಲಾಖೆಯಲ್ಲಿ ಒಟ್ಟು ಸಲ್ಲಿಸಿದ ಸೇವೆಯನ್ನು ಗಮನಿಸಿದಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 3ರಲ್ಲಿರುವವರು ಶ್ರೀ ನಜೀರ್ ಅಹಮದ್ ರವರು 1993ರಲ್ಲಿ ಸೇವೆಗೆ ಸೇರಿದ್ದು, ಕ್ರಮ ಸಂಖ್ಯೆ 2ರಲ್ಲಿರುವವರು 1998ರಲ್ಲಿ ಸೇವೆಗೆ ಸೇರಿದ್ದು, ಒಟ್ಟು ಇವರು ಸಲ್ಲಿಸಿರುವ ವರ್ಷಾವಾರು ಸೇವೆಯನ್ನು DPC ಪರಿಶೀಲಿಸಿರುವುದಿಲ್ಲ. In other words, respondent 1 has joined only in the year 1998, whereas the petitioner has joined the service way back in the year 1993. See, the entire length of service has not been considered by the DPC is one observation. So that is one factor. Second sentence is, ಕ್ರಮ ಸಂಖ್ಯೆ 2ರಲ್ಲಿರುವ ಉಮೇಶ್ ರವರ ಜನನ ದಿನಾಂಕವು 18/5/68 ಆಗಿದ್ದು, ಕ್ರಮ ಸಂಖ್ಯೆ 3ರಲ್ಲಿರುವ ನಜೀರ್ ಅಹಮದ್ ಅವರ ಜನ್ಮ ದಿನಾಂಕವು 1/6/1966 ಆಗಿದೆ. So the other factor is he was born on 1/6/1966, whereas I was born subsequently on 18/5/1968. So date of birth is one other factor. The third factor, ಇವರು ನಿವೃತ್ತರಾದ ನಂತರವೂ ಉಮೇಶ್ ರವರು ಸೇವೆಯಲ್ಲಿ ಮುಂದುವರಿಯುವ ಅಂಶವನ್ನು ಗಮನಿಸಲಾಗಿದೆ. Even after the retirement of the petitioner, there are chances of the proposed candidate getting promotion to this cadre. These are the three factors. These three factors are considered. Honorable Tribunal has extensively dealt with it and has held all of them are irrelevant. All the three factors are irrelevant.
Yes.
And more importantly, I request the court to kindly mark the Honorable Minister's order. Nowhere has he considered the DPC and rejected it.
Yes.
Nowhere has he considered the case of this respondent and rejected it.
Yes.
So it is in this backdrop, I pressed into service that the right to be considered for promotion is a fundamental right, and that right is denied. I relied on Ajit Singh 2 and other judgments.
Yes.
We just point out one judgment and Ajit Singh 2. (1999) 7 SCC page 209. This is a constitution bench judgment. Kindly permit me to show. In fact, this is the landmark judgment which resulted in amending the constitution.
Yes.
Copy ಕೊಡಿ ಅವ್ರಿಗೆ. Para 22 at page 2 to 7 may kindly be put.
Yes.
The heading for this consideration is Articles 14 and 16(1). Is the right to be considered for promotion a fundamental right? Article 14 and 16(1) are closely connected. They deal with individual rights of the person. Article 14 demands that the state shall not deny to any person equality before the law or the equal protection of the laws. Article 16(1) issues a positive command that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It has been held repeatedly by this court that clause 1 of Article 16 is a facet of Article 14 and that it takes its roots from Article 14. The said clause particularizes the generality in Article 14 and identifies, in a constitutional sense, equality of opportunity in matters of employment and appointment to any office under the state. The word employment being wider, there is no dispute that it takes within its fold the aspect of promotions to posts above the stage of initial level of recruitment. Article 16(1) provides to every employee otherwise eligible for promotion or who comes within the zone of consideration a fundamental right to be considered for promotion. Kindly mark it. Fundamental right to be considered for promotion. Equal opportunity here means the right to be considered for promotion. If a person satisfies the eligibility and zone criteria, but is not considered for promotion, there will be a clear infraction of his fundamental right to be considered for promotion, which is his personal right. Kindly pause for a minute. Now apply this test to the minister's note. Where is my case considered? On this ground alone, it has to go. The subsequent paragraph is also important. Kindly permit me to read it. Promotion based on equal opportunity and seniority attached to such promotion are facets of fundamental right under Article 16(1). So my seniority is also my fundamental right. Where promotional avenues are available, seniority becomes closely interlinked with promotion provided such a promotion is made after complying with the principles of equal opportunity stated in Article 16(1). For example, if the promotion is by rule of seniority cum suitability, kindly skip that. I will not trouble the court with that. Kindly come to placitum G. Similarly, if the promotion from the basic level is by selection or merit, this is the case of selection or merit,
Yes.
or any rule involving consideration of merit, the senior who is eligible at the basic level has to be considered and, if found meritorious in comparison with others, he will have to be promoted first. Kindly mark it, sir.
Yes.
This clinches the issue. So if I am found eligible, if I am found meritorious, if I am found senior, I have to be promoted first.
Yes.
So it is on the basis of this law declared by the Honorable Constitution bench of the Supreme Court,
Yes.
that I questioned the validity of the order of appointment of the petitioner as
Yes.
additional drugs control. Also on the ground, this is an act of invidious discrimination against me because my case is not considered and his case is considered, though not recommended by the DPC, though proposal was not before the government, his case is considered. And therefore it is an act of favoritism. Directly I have accused that it's an act of favoritism on the part of the minister to promote a person who is found to be less meritorious than the proposed candidate. Articles 14 and 16 were complained of. Now, so much of arguments are advanced by my learned friend about the writing of the ACRs, about the drugs controller being biased, etc., 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 or my reversion, whether that will confer. My appeal to this honorable court is, sir, the only 3 reasons are given by the minister. They are the only things. Other things cannot be looked into at this stage. As a matter of fact, the arguments tried to be advanced by the other side are all met sufficiently, as opposed to the very government orders in the matter of writing confidential reports, etc., etc. But I'll not trouble the court, but only rest my case with one judgment of the Honorable Supreme Court. Once again, a constitution bench judgment as to how judicial review has to be addressed. Now, this is the famous case of Mohinder Singh Gill's case, Para 8, the celebrated judgment of Justice Krishnayar. Para 8 at page 417.
Yes.
The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw the attention to the observations of Bose J. in Govardhan Das Banji's case. Quote, public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Unquote. Orders are not like old wine becoming better as they grow older. For what I know, he was a stranger to wine.
Yes.
So this is the law laid down by the Honorable Supreme Court, and both these assertions have been accepted by the
Yes.
tribunal in striking down this thing. So far as the assertions made against the relief granted by the tribunal, may I request the court to kindly peruse the prayer made in the application before the tribunal.
Yes.
Page 92. Relief sought for. Wherefore, the applicant most respectfully prays that this honorable court may be pleased to grant the following reliefs. One, issue a writ order or direction in the nature of certiorari, quashing the notification number so and so, passed by the first respondent as per Annexure A1, that has been granted. Two, issue a writ order or direction in the nature of mandamus, directing the respondents 1 and 2 to consider and appoint the applicant to promote him as additional drugs controller.
That has been struck
From
off
2,
and
4
appoint.
Yes, it has been struck off subsequent.
That where is not,
Consider the applicant to promote him as additional drugs controller with effect from 2/4/2014. Now, this is the relief granted. And it was my complaint that the petitioner is not entitled to continue even for a day. I pressed for an interim order on the ground that he has no title to the post. But the tribunal deferred consideration of it when they said they are ready to address the arguments. And therefore, the order has been given. So it was my case that by this order, a junior will be my boss to whom I will have to report. Kindly prevent that this thing. So therefore, further orders have been made. And what is granted is consideration of the case. I am not granted promotion.
Yes.
So therefore, nothing more. One other aspect on which he is not entitled to be heard at all in this court for the kind of conduct he has indulged in. I will eschew from considering, though it is on record, the kind of political pressure he has brought, kind of mudslinging he has done. Sir, on 6/3, the DPC is meeting. He gets my photograph published in a newspaper, in a yellow journal, making allegations of corruption. On 5/3, on the day, on 6/3. So that is the one which I complained to the Scheduled Caste Commission, which he has brought on record. He himself has brought on record my complaint. So the center, and he brought pressure from ministers. 3 ministers have issued minutes to the Honorable Minister for Health to appoint him, directly recommending his appointment. That is also on record. Anyway, tribunal eschewed from consideration those aspects. I will not.
Well, a tribunal is only
One before my. Now, one reason why the assertions made regarding the ACRs or the DPC, legality of the DC, need not be considered is the government itself filed a reply before the tribunal. Kindly permit me to show from the reply filed by the government before the tribunal, which is placed at page 385. 385. This was filed on 2/5. Para 388 may kindly be perused. Page 388, para 7.
Yes.
Para 7. It is submitted that the respondent number 3 was promoted to the post of additional drugs controller as the applicant has another 4 years of service, whereas the respondent 3 has 2 years of service. Hence, the applicant has a chance of being considered for additional drugs controller post. Hence, the promotion of respondent 3 is not discriminatory and arbitrary. That is one assertion. So far as the allegations regarding the procedure followed, kindly come to para 8. It is submitted. Respondent number 1 and 2 have duly followed the procedures, office orders, as well as regulations of the KCSR while writing the confidential reports of the officers based on their performance. So it is the government case that they are properly and validly written.
Yes.
Also, one more paragraph, para 9, that may also kindly be marked. It is submitted that the workflow of assigning the confidential reports of officers for the period of 2020-21 onwards, one by wide order dated 28/7/2023, and officers have been graded as per their work performance. It is their case that all the ACRs are written according to the government order. It is this government order which I wanted to place before the tribunal, which my learned friend first refused to receive the copy, then made a hue and cry that no application is filed, it can't be looked into. Be that as it may, I relied on the statement of the government, and tribunal has accepted it. So it is the government case that everything is in order. The ACRs are in order. DPC proceedings are in order.
Yes.
Please, grateful to the court for a very patient hearing.
Orders passed, second direction was issued to reconsideration only.
Yeah.
We'll
Yes.
reconsider the order as per our statements made before the authorities. Till then, they don't have any cause of action to file this petition. That has to be considered as per the direction issued by the Honorable Tribunal. Will consider pass and appropriate orders in accordance with law as per the direction issued by the tribunal. Entire thing was covered by the seniors. I don't want to say anything.
Yes.
And government has not preferred any writ petition. They have accepted the
We
order.
have not.
That's, please, grateful.
Kindly take the, page 215, because after the application was reserved for orders on 25/4/2024, 16 documents are produced. Annexure E, page 25, 215. I objected that this 16 documents cannot be taken on record because there is a procedure now under law. You cannot take into record. Tribunal says we will pass the order during the course of the application. Even after admitting, court must give an opportunity. Yes, what do you say about we are admitting? Where is the the petitioner can go through these documents unless it's admitted. Court has not admitted before, when it was heard. No, court said we will consider it whether to admit or not to admit. And those documents are relied by the tribunal, particularly 350, which is A20 page, which is read out to this court, page 350. Part of those memo documents.
Where is the reliance on A20?
That is what he is senior. That is what court says. He is senior. Court says he is senior to me, though he is junior in the cadre of drug inspector. 1993, he was appointed as a drug inspector. I am appointed as a 1993. He was appointed.
Admittedly, the rules say
Yes.
that seniority is to be reckoned in the cadre of deputy drugs.
Yes, yes. That I agree, my lord. I do not say that. But question is now, my lord, these documents produced before the court, I have no opportunity to say about it.
Yes.
16 documents, it should be produced along with the main application or main application. Tribunal simply admits it, discusses along the application. Then, my lord, how these judgments, my lord, in constitution, when judgment has absolutely no application. Why? Because it is a fight between the reservation and, my lord, non-reservation. Supreme Court said it must be according to seniority. A CST cannot overlook it. Because kindly see, here in Karnataka, promotion is provided in reservation up to class 1 junior scale. not beyond that. They have to come in the order of seniority. Lord, this judgment of Lord, Constitution bench judgment says, Lord, in the order of seniority, you have to consider fundamental right. It helps only for non-reservation. Not for the, but how in Article 335 would apply? Is it reserved post for the SC, ST? And you see, it is a post, right? Promotion by selection by promotion. That is the reservation for the post of additional controller. How 335 would apply?
Yes.
Here is one provision in the Constitution. It cannot be read into in the matter of promotion unless it is, right? Article 16(1) is a fundamental right. Proviso to Article 16(4) is only enabling provision to provide promotion in reservation. My lord will remember in Indira Sahni, the 9th judge, far back in 93, there is no reservation in promotion. Till there is no reservation in promotion. That's why then they overruled the judgment and amended the Article 16, adding that reservation in promotion with consequential seniority with effect from 1/6/1995. That is the discussion, Lord, is the Ajit Singh Jadeja 3 Constitutional judgment, which will come into effect from 1/6/1995, on which date constitutional amendment has taken place, reservation in promotion with consequential seniority. That is what court said, Lord. Article is so amended. Therefore, Lord, this judgment has absolutely no application. But 78 judgment of Lord has absolutely no application because reasons are assigned. There are that, but reasons may be arbitrary. I'm not saying that.
Yes.
And one more question is not the head of the Department drug controller, who is personally interested, no authority under law to not accepted written the CR of the
Yes.
respondent one. He has no authority. I showed the rule also. Who has to write it? Immediate senior is the additional controller.
Yes.
Therefore, my submission to your lordship is the
Please.
till the may not pronounce the order, and even interim order. Something may take, we don't know.
Consider that.
Yeah.
We consider that as things stand.
I oppose any
Yes, sir. But-
any interim prayer at this juncture.
Something,
Matter is fully heard.
Interground something happens, my lord. That's the difficulty.
Interregnum something happens, the judgment will correct.
Right?
Interregnum, if something happens, the judgment will correct it.
It will happen, my lord, because he says he
It will correct it. If interregnum, whatever happens, will be subject to the judgment. Yes.
Please.
Matter 230, till number 35, Navi Dama.
Thus, we have paid the court fee, my lords. The office was showing 130 as court fee, but as per the decree, we are supposed to pay 258. We have paid the entire court fee, my lords. Deficit court fee of 258.
Court fee is paid. Sorry?
69 lakhs is the.
Has he not paid the court fee? Court fee is paid, right? That was your objection.
For court fee, I mean.
Tenure is over.
Lords, tenure is expired, my lords. That's the only thing, lords. I need another 24 months, my lords, to vacate the premise. That is the instruction, my lords.
What are you doing there?
Lords, I am carrying out the business, my lords. This is a, lords, used car. He is having a dealership of used car, my lords.
Dealership of
Used cars, not.
used cars.
Yes, old cars.
Since how long you are doing that?
Lord, since 2010, Lord.
He needs reasonable time to vacate.
Lord, I will pay the rents. I will pay the rents and will also continue to pay the future rents as well, my lords.
What is the rent agreed? 1,50,000.
No, my lords. My lords, under the, my lord, before this court, my lord, 72, prima facie, my lord, 72 was, my lord, fixed, my lord.
Then
Plus
what's the agreement?
125 is the agreement, my lords.
125.
125 is the agreement.
Earlier, they said 60, they said.
What the agreement says?
Agreement says 125, my lord.
There is a stop.
120, my lords.
Seconds. Just a second. Sir. Agreement dated.
As per agreement, 1,25,000 per month for 8 months.
That's what I'm.
Thereafter, as they failed to vacate, 1,50,000, I have produced documents to prove that 1,50,000 is the agreement. They were saying, they were depositing the amount to the bank.
Just a second, sir. How many agreements were there? One or two?
Latest agreement I have produced, they have not produced any agreements.
You have produced latest agreement. Mark
P13.
P13.
Lords, exhibit
I have
P30.
copy of that,
Under that agreement, 1,50,000 per month.
1,25,000.
Yes.
1,25,000.
That is, I am admitting it, my lords.
1,25,000 for 8 months.
Uh,
After 8 months, 1,50,000.
Is it-
Thereafter,
Just
they
second.
transferred amount of 1,50,000.
Just a second, sir. Is it provided in the agreement that there shall be an escalation? Is it mentioned in the agreement there is an escalation?
Exhibit P13 is the agreement. I have copy of it also. To prove the rate of rent.
Just a second. You are admitting at rupees
120, yes, my lord.
based on the same agreement.
Yes, yes, my lord.
The same agreement according to him provides for an escalation.
Yes, my lord.
So that comes to 1,50,000 per month.
Lords, escalation, my lords, is 10%, my lords.
Sorry,
10% is the escalation, my lords. 10% is the escalation, my lords.
for how many years?
Lords, for next year, my lord, for,
For every 11 months.
every 11, after expire of every 1 year, my lords, every year.
Then it may exceed 1,50,000.
Lords, the lease agreement, lords, latest lease agreement, lords, is 2018, na?
17. Rent agreement 2017. It was specifically agreed in the agreement. For 8 months, 1,25,000. Thereafter, 1,50,000. At the rate of 1,50,000, they have transferred amount to my account. I have produced a bank statement also, and they have admitted, yes, this is the amount paid by us towards rent.
Para number 12 covers all these aspects. It has extracted your admission or noted your admission rather.
Lords, admission, lords, I noted, lords, para number 12. Lords, he admits, lords, that lords rent was 150. Lords, not under the agreement, lords. Lords, agreement says, lords, it is 125.
Why did you pay 1.5?
Lords,
No tenant would make charitable payment towards.
I know, my lords. Lords, some reasonable friend, my lords.
Continue to deposit 1.5.
Lords, whatever due as on today, lords,
What is the due?
69 and 69 lakhs. 69
lords,
lakhs.
out of 69 lords, 42 I have paid, 40 lakhs I have paid, lords, under, before the trial court, my lords.
After giving direction to pay deposit, 69 lakhs 78,750.
Lords, kindly see, lords, the payment what I have made before the trial court, lords. The DD is here, my lord.
We have to start this. At least on this count, there should not be any dispute.
I have given deduction to the deposit made by them.
Lords, on a sum of rupees 150, my lords, they calculate up to 97,50,000, lords.
Total 1 crore in due. They deposited 3960 and after giving deduction to 60.
It appears probably he has not calculated interest.
Lords,
Decree directs payment of interest.
From the date of the decree, my lords.
Sorry?
From the date of the judgment, my lords.
For arrears.
The agreement provides.
The
for
defendant is
3%.
directed to pay 150 per month towards damages for illegal occupation of suit property from the date of the suit till vacating it.
Correct, date of the suit.
Yes, my lords.
How you have calculated from the date of the suit?
Per year, 18% on 4.5 lakhs. I have calculated. Comes to 4,38,000.
No, right now, don't insist for interim order, don't insist for that interest.
I will
Interest
not
from-
do that.
Excluding interest, how much it will come?
Interest between 63 lakhs.
Only. Only 3 lakh, and what is interest component?
4 lakh.
Interest 4,38,000 bitre, 62 lakh or something. For
50 lakhs has been paid.
He says 40 lakhs is paid.
He admits the 39,
They have paid 39 lakhs 60,000.
39 lakhs
I have found it in my never calculation. I have given deduction to it.
So interest component is only 4,38,000.
Interest, without interest also, it comes to 62 lakhs and. Interest is not clear.
15% from 1/1/2019 to 30.
This is from the date of the suit, my lords. 1119 is the date of the suit.
No, just a second, 1,50,000. From which date you have calculated?
1/1/2019.
Lords, from lords, after the termination of the tenancy, my lords. That is from 1/1/2019.
For how many months now?
Almost 64 months, my lords.
That date you admit?
65 months.
No, just a second, that date you admit?
Yes,
That 1/1/2009 is the
Yes, yes,
default
my
date. So 65 months, according to you, according to 64.
Lords,
All right,
have no issue, my lords. 64, 65, no issue, my lords.
all right, 65 into
150. Okay, we should-
Interest is not awarded on 1,50,000. Only arrears, 3 months arrears were there, on that interest is awarded. Prior to filing.
97,50,000.
Lords,
97,50,000
yes, my lord.
minus what you have paid,
Minus
32,000.
3960.
60,000.
Lords, my client says not 40 lakh, 60, 40, 42 lakhs he has paid, my lords.
40 lakh 32,000.
40 lakh, 30,200, 32,000.
Forty lakh?
32,000.
So 57 lakh 18,000. 57 lakh 18,000
57.
without interest.
Lakh 90,000.
18,000.
18,000. So 57th lakh 18,000 is the amount due.
Lords,
Taking it as 40 lakhs, something 42 lakhs. something
40
like
lakh, 32,000.
Arrears of paid as of now, this is also including the degree. 4 lakh. 1 is 4 lakh.
Reverse calculation. 9750 में से
that. They're agreeing on the default date. Default date.
ये निकालो पहले ये निकालो ये minus करो इसमें से जल्दी minus करो.
Today they have calculated. So you have calculated the date from 1/1/2019 till date, right? Till date. How many months? 65 months.
65.
64, whatever. So that comes to 5,71,800.
Lords,
Sorry, 57 lakhs.
57 lakhs, no, 57 lakh 18,000.
You really said yes.
No, 57 lakh 80,000, 18,000. I'm sorry, my lord. 50, I just noted down, 15,7 lakh 18,000. कितने महीने आते हैं 1119 से आज तक 20 को एक साल
So first you have to deposit the arrears.
Lords.
Then we can think of a reasonable period for vacating.
Lords, if Lords grant me Lords reasonable time, Lords I will deposit.
You agree upon, both of you agree upon, instead of we imposing a period. So take into consideration, because he's a second-hand car dealer, probably he needs a large space which may not be readily available.
Because my clients are all doctors. One of our doctors was in USA or something, they have come back, they wanted to start a hospital there.
No.
For this they are waiting.
All right, we will ask him to deposit the amount. That is one of the conditions precedent. Apart from that, both of you agree upon a
कितने time
reasonable
में
time.
6 months.
You have to file an affidavit.
Yes, affidavit and undertaking
Yes.
subject to payment of
Yes.
paying which
I need to know what is the time, maximum time that you can grant.
No, we'll have it this tomorrow. We agree upon the period. Tomorrow.
All right. Lords, day after, Lords? Day after tomorrow. Tomorrow, Lords, tomorrow, Lords.
because warrant is also issued, we are not taking.
200 tomorrow.
Because I met him.
We agree upon the time frame.
Till I will not, till this is completed, I will not.
I try my Lords, I try I take my chance, Lord, before my learned friend. Tomorrow, Lords.
Tomorrow.
Nothing on law to be decided here. You have to agree on the.
I agree, my Lords. Public Lords.
Passed on matter, still number 14. Shashidharar.
Appear for the appellant's minutes. I believe both the senior counsels are on their legs in this matter. So, short date may be given.
Senior.
Maintainability.
Maintainability. Date can be fixed. I'll place all the citations on record and I'll serve a copy to the other side.
Against the ex parte order.
Against the
Order refusing ex parte injunction.
Yes, ma'am. There are also certain additional document that I'd like to place on record, which I placed along with my. If I may make my submissions, I'll make my submissions. If not,
Sorry?
if I may be permitted to make my submissions, I'll make my submissions with respect to maintainability.
Next date.
Please, Manoj, then I'll just like to place some documents on record. So that
Citations.
citations I've already submitted, certain additional documents which I've already placed before the trial court as well, along with my rejoinder. I'll serve a copy on the other side. Any short date, Manoj?
1/7.
Side. I'm grateful, Manoj.
Group matters. Till number 23. Rangnath S. Joyce.
Matter relating to disciplinary proceedings, Manoj. Two armed police constables were proceeded against in disciplinary proceedings and punishment of dismissal from service was imposed. In fact, this matter was heard at length before the previous bench, Manoj. And the question that arose was whether a fresh and because initially proceedings were initiated for imposing a minor penalty. Thereafter, noticing that it was incorrectly initiated, there was a new inquiry initiated for imposition of major penalty. The allegation is
Will that amount to imposition of a de novo?
whether it amounts to whether
Or whether the procedure can be altered midway?
whether a second inquiry can be held at all on the same charges was the question that was posed by the court.
If,
To the,
as a matter of fact, the first inquiry had ended, resulted in an inquiry report, the second inquiry cannot. If hearing, if you take proceedings for major penalty, and ultimately find that all that is to be imposed is a minor penalty, well and good. You
the
can-
first inquiry proceeding.
Converse may not be correct. Because if you initiate proceedings only for a minor penalty, you cannot midway alter the proceedings and make it a major penalty.
That was not done, Manoj. In fact, the first proceedings was cancelled. The Assistant Commissioner of Police writes to the Commissioner for initiation of disciplinary proceedings. And the Commissioner, and he himself initiates proceedings. The Assistant Commissioner himself initiates proceedings for imposition of minor penalty. Thereafter, after 15 days, without knowledge, oblivious of the fact that proceedings have been initiated for imposition of minor penalty, the Commissioner also initiates proceedings for imposition of major penalty.
Parallel.
Yes. Parallelly, it goes on, then because it's done in a summary, only notice is issued calling for reply. And based on the reply, a minor penalty of imposition, fine is imposed. That has been cancelled and the major proceedings are continued. The allegation was there are a long line of decisions on this point by the Supreme Court, my lord. I have them ready. Also, I'm relying on a provision of law under the Karnataka Police Act, which provides the superior authority the power to supersede the actions of the subordinate officers. I'll place that.
To override the provisions of the classification control of the rules or the rules for conduct of the proceeding. Because once a minor penalty proceedings are initiated and they have ended also.
Ended, but not imposed, my lord. It was not.
The finding is rendered.
Finding is rendered.
Does it not amount to double jeopardy?
Look, it's held by Supreme Court that double jeopardy may not be applicable to disciplinary proceedings. From the times of Honorable Justice Krishna Iyer, many subsequent decisions.
Is it under?
But they have held that. New fresh inquiry cannot be conducted on
Inquiry normally is not.
the same charges. But only if there is some mistake in law, then it can be done. That is the position of the Supreme. I'll present those. Perhaps nobody anticipated that the previous case would end.
Probably. Yes, we'll have it on another. 3/7. 3/7.
Please.
26, Srikanth MP.
Waiting for petitioner, my lord, kindly out short.
What is the matter about? You're only representing.
Matter in respect of counting of earlier servicemen.
Ah.
They have resigned it.
Yes, resignation to take up another employment,
Resignation was accepted. They have filed a resignation, which was
plain
accepted.
resignation.
Yes,
It
madam.
is not for the purpose of taking up another employment.
No, madam.
Yes. Continue.
57. 27.
Petitioner. This is the disciplinary proceedings, Lords, which resulted in compulsory retirement of a first division assistant. My Lords, this was a complaint given to the Lokayukta regarding a bribe demand made by two sub-registrars. Against both these sub-registrars, one, the inquiry itself is not initiated, stating that he's already retired at that point of time. Against another one, in the inquiry report, it says that there is no evidence against that person. Only in respect of the petitioner, it is held to be proved. Let's, the petitioner is a first division assistant. The allegation against him is neither demand nor receipt of the bribe. He issued, the complainant gives complaint against two sub-registrars that they have asked for 18,000 rupees bribe. It is then the shadow witness and the complainant is sent, and it is catching them red-handed. When they, What is your role? My role, when the complainant says, when I went to give the bribe, the sub-registrar shows the petitioner and says, hand it over to him. They go and they say, take it. This petitioner says, no. He takes it to the second sub-registrar and he says he has brought the DD for release of his document. Shall I release the document? He's a first division assistant. He's not the registering authority. So he says, has he got the bribe? That's what the complainant says. Has he got the bribe money? The complainant says, yes, I have brought the bribe money. Then he says, take the bribe amount and ask him to come at 3 o'clock. Even then the petitioner doesn't receive the amount. It is the allegation, the petitioner took them into one chamber and there he asked the complainant to hand over the bribe money to one person, Nataraj. He is a document writer. This is all. This is the role of the petitioner, even as per the allegation. The complainant, my lords, is not examined. He is not at all examined. Only the shadow witness is examined. The complainant, for whatever reason, he's not examined. Shadow witness is examined. One punch witness is examined. IO is examined. These are the only three. And there is nothing beyond this anybody can say. There is neither receipt nor demand of bribe by the worst situation. He has, my lords, the tribunal and the inquiry officer say the petitioner did not step into the witness box to say why he asked the complainant to hand over the bribe amount to somebody else, who is not at all from the office. This is the thing. But the complainant was, the petitioner was not feeling well. So he went home, is his explanation. None of them have seen except the complainant, and the complainant doesn't step into the witness box. Only the shadow witness says, I have seen the complainant telling the complainant to hand over the bribe amount to some Nataraj. This is all the allegation. My lords, based on the same set of facts, same documents, same witness, there was a special criminal proceedings were initiated. There, after the complete recording of evidence and everything, they have been acquitted, my lords. They have considered all these aspects and said, none of them, even handing over the amount is not proved, because even there the complainant is not examined. He is not examined. So my submission, my lords, I have no role to play. Why am I being two sub-registrars against whom there was demand and payment? They are let to go scot-free. I have been made a at the most, my lords, I have listened to my superior. I've just asked them, and my lords, there is a discrepancy here. he has to get two DDs for release of the documents. One is around one amount, another is 18,000, the bribe amount. That amount DD was to be given to me, not to me, to the two sub-registrars.
Bribe is also demand draft?
It's not demand, it's cash. It's cash, my lords. And there even only that Nataraj is caught red-handed. I have not even touched the money. I have not asked, I have not received. I'll I was just a first division assistant. This is the incident of the year 2005, my lords. I was just a first division assistant at that point of time. I'm not demanded. I've not asked him to pay to me. He told collect the money and ask him to come at 3 o'clock. I did not even collect the money. I have handed over. My lords, for all we know, it could be the amount. I mean, giving that amount to only Nataraj tells the
Document writer,
to the document writer.
why should, if it were the amount that is due as, to the department for releasing a document, why did you go and give it, ask him to give it to the document writer?
My lords, only, there is even Nataraj is not examined. It's my case that I have not told. I was not there in the office. I had signed, but I was not there in the office. Nobody has seen me. They are trapping me in a false case, my lords. That is my case throughout. But yes, I did not step into the witness box. I did not do that. That is for sure. I did not give proper reasoning why I was not there in the office. I have said, nobody has seen, my lords. Either the Lokayukta police have not seen me, the punch witness has. Only the shadow witness has. Shadow witness has. And the complainant apparently has, but the complainant doesn't step into the witness box.
Even if it's only a dismissal proceeding, there is nothing compelling you to enter the box.
Yes, yes.
This is up to you.
It is up to me. And I have made all suggestions that you have not seen me, and I have not told the complainant to hand over the amount to Nataraj. I have not told. I have made such suggestions to the shadow witness. It's my case that I did not do it. There was one DD, I went to my superior, I showed it to him, is what they say. I showed it to him. I said, can we get this document released? Because of deficit of stamp duty, that document is kept impounded. So can we release it? He says, collect the amount and ask him to come at 3 p.m. post lunch. So it is their allegation that I took him to that Nataraj, which I deny. There is nothing either in this, even at least Nataraj could have been examined. Even he is not examined.
Acquittal is honorable?
Yes, it's honorable. Everything, all the evidences are looked into. It is honorable. Even there, my lords, from 2005, I've been into a real, I have not received the amount. I've neither told them I will. I need and that document was not registerable by me also.
Just a question.
That's a different question.
We are
The scenario, I'm well aware. Yes,
Yes. One person asks for the.
Yes.
Takes it and keeps it to himself.
yes, yes. We had occasions in
But he-
sub-registrar.
Everybody-
Yes, yes. In sub-registrar office, Malaks, we have ourselves seen that they show us the calculator and they show us, we have seen it personally. But here in this case, I have not demanded, I have not received, I have not even suggested it to the complainant to give it to the writer. And the sub-registrars against whom the original complaint was made, both of them, one who retired even prior to initiation of inquiry, he's just left to go scot-free. And another person, they say there is no evidence. Well, if there is no evidence that he demanded the bribe, to whom would I give then? What amount did I give? It is a complainant specific case.
One of the accused in the criminal proceedings.
Yes, 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 yes. All the four of us, that is the two sub-registrars, Natraj and myself, all of them are acquitted. Well, in the inquiry, the second sub-registrar and me are we both are, we face the inquiry. There they say it's not proved, the shadow witness does not prove him telling the petitioner to receive the amount and to ask him to come at 3 p.m. If he has not asked me to tell the complainant, then that link itself is not there. The inquiry, they say that the sub-registrar did not take.
Sub-registrar, it is held not proved.
Yes.
As against you, it is.
Hey,
held
only
proved.
me it's proved. First sub-registrar is left. They do not initiate inquiry at all. Because they say he's already retired, we will not initiate. The
What does
second.
the tribunal say?
The tribunal again says only this much, that they did not, the petitioner did not step into the witness box to say why he told Natraj. It's my case, I never told. At least that you should have stepped into the witness box and you should have.
Next week, Miller.
Can this aspect be considered when was the acquittal?
Acquittal was, Milots, when it was pending before the tribunal.
12th January
12th
2023.
12th January 23.
23. So a review petition was filed before the tribunal. The tribunal says the circumstances are different. I can show Milots, the charges are the same, the witness are the same, the documents are the same. The inquiry is exactly similar
Not
to the
binds on
charges.
them. If departmental inquiry is different,
Yes.
the finding of the tribunal is departmental inquiry is different, criminal proceedings are different.
But it is on the very same.
Very
allegations and with the very same witnesses.
Prevention,
Could it not be considered by the dispute?
GM tank and
Substantial.
GM tank and subsequent.
Next.
Yes.
It is held in detail, my lords. All the evidence is held in detail. And they say even demand is not proved because the witness did not.
They say about you.
About me also, because the demand,
Finding of the criminal court of
the tribunal again says, my lords, there is no evidence against me.
criminal court.
Yes, my lords, even the criminal court says. Only the inquiry officer says, the witness, the shadow witness has deposed that he goes, he says, the sub-registrar did not ask the complainant to give, but insofar as I am concerned, he says, yes, the petitioner.
Shadow witness was also a witness before the.
Yes. The complainant was not examined in both the places.
Which case decided first, criminal case or department inquiry?
Department.
Department.
And the first instance, they're all.
You produce the special case court judgment to the.
Yes,
before the
yes, it's a
tribunal?
part of.
Before the tribunal?
So yes, my lords, we filed a review petition saying that this has happened. The tribunal says, just my learned friend submitted that they are on different aspects and that cannot be considered. But we argued on GM tank. We said it's a similar facts, similar charges, similar witness, and absolutely similar records. Prevention of Corruption Act, there, here, everywhere. It's the same thing. There's absolutely no difference between both of them.
If those contentions are correct, please tell us whether it can be the.
Yes, ma'am.
If it is an honorable acquittal, whether it can be considered by the dispute.
Yes. Next week, Miller.
Also, please. Next week.
Public.
Second week. Second week. Second week. ಜಾಸ್ತಿ ಇದು.
5-7.
Last paid.
Paisa.
What do you mean?
Monday kodi next Monday.
Ninth ತಗೋ.
Ninth kodi.
Ninth.
Publish.
I just make one comment. The question of applicability of useless formality to disciplinary proceedings. I examined Karnataka case and also I found that there are decisions of the Supreme Court which explain how Karnataka case has to be interpreted. I believe that it will be applicable, my lord. I'll just make a 1 minute submission at the end of the day when my learned friend is there and I will submit the judgments. Because I'll submit it
Yes, tomorrow.
tomorrow.
ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್ ಅಲ್ಲಿ 28 ತೋರಿಸ್ತಾ ಇದೆ
You and the useless formality.
There are several judgments, therefore I went
Yes.
through several of them.
Tomorrow day after wait, anything.
Tomorrow itself, I'll just take 1 minute and in front of my.
No. Does not have to be listed or do you want it listed? You want it listed?
If it is listed, it can be taken up tomorrow. I'll just take 1 minute, I'll make that one submission and there are two issues, my lord, in Karnataka case that I will point out. So there is it appears it is mandatory for the High Court to decide whether prejudice has been caused and it is for the petitioner to prove that prejudice has been caused. I'll submit that
Prejudice.
by non-consideration. In this case, the question is,
Prejudice has most definitely been. When you say that there is an honorable individual, has not been considered.
question is violation of the third principle of natural justice, that is, it is not a speaking order insofar as non-consideration. There is no reason regarding whether his honorable acquittal will have a bearing on the discipline.
Even otherwise, is this a manner in which an appeal is to be decided by an authority, I mean, manner in which a second show, or a reply to a show is to be considered by the.
It appears that the Supreme Court leaves it with the High Court to consider whether there was prejudice caused. That question has to be answered. I'll bring it to the attention of the court.
Lord, I have relied upon one judgment which says that, my lord, useless formality theory, whether if opportunity is given to the other side to show cause as to why action should not be
They
initiated.
have nothing to say.
Lord, it is not for the authorities to say. It is for the court to say whether useless formality theory can be applied in the given circumstances of the case. Not useless theory, not the authority cannot presume that opportunity, if opportunity is given, it will not improve the case, therefore I will not give.
It's not his case.
It's
What
not
he would say.
This is for us to consider also. He says that in instant case, nothing would come out of it.
No, the outcome will not change.
Let's see.
Of course, he is, Lord, he is trying his level best.
Both of you.
Madam,
No,
but it is my bread and butter.
our worry is in cases of this nature, if we say that, I mean, go on technicalities and say that there has been these are matters where corruption is involved. What is the message that we are giving the?
Please,
We have
Lord.
argued everything.
The message that we
Whether the
give to the.
Supreme
But we have argued, my lord, and we have troubled enough, but my lords may.
I'll only
Yes,
point out the
I am not saying, my lord,
grateful.